Good morning, good morning, good morning, or good afternoon. We are here for the Darrell Brooks sentencing scheduling hearing with the court. It's supposed to start at 1 p.m. Central. The judge has just taken the bench and is a little bit early. They are doing housekeeping matters. It doesn't seem that Brooks is in the courtroom yet. So we are going to be going to that immediately. But this hearing is scheduled to start in just about 10 minutes. Brooks is in the courtroom in orange jail jumpsuits. And we know that just because this hearing is scheduled to start in about 10 minutes doesn't mean he's not going to say something. So welcome in. Thank you for being a law nerd. We've got a poll going. Don't forget to take it. Replay crew, love you. There will be chapters down below. I'm going to roll the intro and we're just going to go into court and see what happens. So let's just do the things.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
So the court had been on screen. I'm just going to show you real quick our screen. The court had been on screen and now is not. Now they've gone back to the clock on the wall. So this hearing's not going to start or not supposed to start for another, 5 minutes at this point. We're going to answer some questions about what this is about. And I'm just going to keep monitoring this on my monitor, and then we'll go back into court when they zoom back into court. So first, happy Halloween, everybody. I've got my skull. This is it. This is Tired Mom is my Halloween costume. That's all I got today. We had a nice weekend, went out of state for a band competition. Things that when you live in Southern California, you can't just drive a few hours and be out of state. And in Tennessee, it's like, yeah, we're heading to Alabama and then to Georgia and then back to Tennessee. It's like, whatever. So welcome in. Let me know where you're coming in from. Kim Cheney, good to see you, lady. Let me know where you're coming in from. I've got all the water today. That's just, we need water. Tonight, though, one of the things I love to do in my neighborhood when my neighbors come around to trick or treat is I make spiced cider and allow them to choose if they would like it to be spiced cider or not spiced cider. And I hand out treats for the parents too. So it's always cold. It's so nice. In California, there were Halloweens where it was like 80 degrees at night and you're like, ugh. So it's really nice to be able to do that here. Miguelina, I'm going to leave the poll until court starts. Once court starts, we'll end the poll. I need to let the law nerds in the text community know that we're here. The text crew went through some growing pains during Depp v. Heard, but we are back. This is a sentencing scheduling. This is not a sentencing hearing. We still don't know what he's going to say. I'm sending this text right now. Come join us. Text crew represent. The sentencing scheduling is to see how many impact statements the prosecution anticipates, how long that'll take. If Brooks is going to make a statement, if Brooks is going to have people speak on his behalf, they can. There's not a lot of leeway in this sentencing. It's probably going to be hundreds and hundreds and hundreds of years to life plus life plus life plus life forever. But they are still allowed to make statements. He's allowed to make a statement on his own behalf. I think it would be a lot of, well, maybe not. It could be a lot of what we saw in his closing argument. But at that point, he was pleading to the jury for mercy. He was pleading for juror nullification. Here at a sentencing, there's no jury in the courtroom. So he might just be a little more, I don't know. He seemed to honor the victims when he gave his closing, or tried to, even though he said his conscience is clear and he has no regrets and who knows why God does what he does. It's all his will and whatever. We might see more of that in his impact statement. We might not. We might see him saying this was all a sham. This was a rush to judgment. We might see him arguing with the court. I imagine he'll do that today, but I don't know if he'll do that today. So we'll see what happens. He looked subdued in court when it pulled up. We've got 2 more minutes. Hopefully they'll pull this up. And then it seemed that the court has a hearing after this. So I imagine the court will keep some control over this. The court needs to, or might, I shouldn't say needs to, the court might allow him to make some more statements on the record. There was not much that the court got to do at the end, or that Brooks got to say after he was convicted, which was, I think, the absolute right call on the judge. The judge was like, and we done. And, we're done. No chance for him to process what happened and go off the rails. We'll see what happens today. Today, he's probably going to be shackled a little bit differently. And we'll just see. We'll just see what happens. So that's what's going on now. The court has not resumed yet. We're going to answer some questions. And yeah. Z asked, what was the largest sentence judgment in your cases? So I was a deputy district attorney for over 10 years. For those of you that are new, you are welcome to put a 1 in the chat. On Facebook, I will see them too. If you go ahead and put a 1, I was a LA County deputy DA for over 10 years. In my personal cases, life without parole was the highest sentences. Some of those were like 300 years plus life without parole, some higher, but life without parole, like the possibility of never getting out. So life without the possibility of parole, LWOP, were the highest sentences in my cases. And those were in the most serious cases, including homicide cases. So that's what that is. So for all of you that are new, the mods are here to make sure that we are all law nerds, because we have some chat rules. The reason we have chat rules is because we keep it compassionate around here, and we don't disparage. Even though Brooks is hard, James Spears is hard. There are some individuals that are hard to not name call, hard to not try to diagnose. Some of you are medical professionals in the chat. I'm certainly not. And as a chat, I find that saying, oh, well, he's this or he's that is hard, especially when those things are mental diagnoses. So we keep the name calling out of the chat, and we just talk about what has been done, what's happening here, and the behavior that we see, which is fine. Sometimes it's difficult because I know the mods have been trying to make sure that we're not calling him names, but also his behavior has been childish, and so there gets to be a little bit of a line that we make those decisions on. And I appreciate you guys for keeping it non-vitriolic. Some of the chats across the internet, in this case particularly, have been horrific. I don't know if you've been in other chats, but they've been horrific. They've been horrific with just horrific. And we don't do that here. So let us get into some questions and just wait. So don't forget our love of Dr. Spiegel. I mean, we did with Dr. Spiegel take a little bit of leeway with the rules, because I did call him Dr. Doofenshmirtz a couple times. The dude looked exactly like Dr. Doofenshmirtz. And
Old Call State of Wisconsin.
All right, the case is getting called now.
21 CF 1848. May I have the appearances?
Let me see if we've got a okay, there we go.
Please state your name for the record.
Representative from my client. I'm here. I set for value in return for value all of the charging instruments in this matter and make my exemption available.
We still have not
Discharge
addressed
all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and state for the record that I do not identify by the name stated.
We still have not addressed
Record
subject
to
matter
reflect that
jurisdiction.
The individual known to this court as Darrell Brooks is present in custody in person. He is appearing in jail attire today.
There's no
Court
jury.
is here
That's
to
appropriate.
address a couple of things. Of course, the scheduling of sentencing. I also want to address a letter that was sent to the parties late last week on the 28th regarding the unsealing of search warrants.
Who wrote the
filing
letter?
From Mr. Brooks. And then an issue just as it relates to the record and the use of restraints during the trial, given a statement that was made by Mr. Brooks when the jury was coming out
To take the shocks off.
after they had reached their verdicts.
Oh, he's not
So,
going to love this conversation.
I'll start with the
I'm here
search
for
warrant
it.
issue. The parties should have received the letter dated October 28th, advising the parties that the court will be unsealing all of the search warrants tomorrow, November 1st, unless there's an objection that is raised. Of course, that's based in law and fact. And I indicated in that letter we would address any objections at this hearing. So I'll start with the state. Do you have any objection to that?
No, Your Honor.
No, he's in the courtroom.
I have not received anything. I'm quite sure or I don't know if you knew, but the very second that I left your courtroom Wednesday, Your Honor, I was placed on suicide watch. I was told that it was
That's protocol.
jail administration.
Yeah, that's protocol.
That it was policy.
That's
There
protocol.
was nothing I could do about it. They immediately took me right from court, stripped my cell. I talked to mental health. They changed me right over into the SMOC.
That's protocol.
And I was basically placed on that. They just gave me regular clothes maybe 10 minutes before I came to your courtroom, Your Honor. So I haven't. I wasn't
printed it
allowed
off.
any
We'll give
mail.
it to you.
What he's trying to say, I think,
I had the letter printed off, and we'll give it to you now so you can take a moment to review it. It really says everything that I just put on the record just now as well.
he hasn't
I
yet
accept the value
mentioned
and
subject
return
matter
the value of this
jurisdiction.
document.
Hasn't said it yet. You can take the mask off. So it's protocol to put people that are convicted, especially
I would just note there's a typo in your name.
with this many
So my apologies for that.
convictions, to put them
No
on
initials
immediate
indicated
watch.
wrong.
That's jail protocol.
That does reference.
So
the
his
case
point,
number.
I think, Kayla in the chat, his point, I think, is I haven't seen this yet because I was put on watch. So we ended the poll with over 8,000 votes of will Brooks mention subject matter jurisdiction at this hearing? Yes, immediately, 54%. Yes, at some point, 36%. No, he will refuse to participate. 6%. No, he will be muted.
When was this letter?
2%.
Because like I said, I've been on watch, so I haven't
Yeah, he wouldn't be allowed to have paper or
been able to
anything.
obtain any mail.
Yeah, he wouldn't have
whatsoever.
any
Not-
mail.
Not from the courts, not personal mail, not anything.
So that was signed on Friday and then sent over. I'm not sure if it was emailed or if it was just delivered to the jail. I don't know if Madam Clerk has any.
You know who would have
information.
received it
was
without
done
a
by my
concern
clerk,
after
but
he
in any
was
event, you have it before you. What I
after
can
he
tell you,
was
sir, is
sentenced?
that,
His lawyer
normally,
His lawyer would have
search warrants
been able to do
may
that.
be sealed for a period of time. All of these warrants were set to be unsealed previously, but due to
The public nature of the case?
pretrial publicity and the
I did go to BOA.
various
Ray.
orders related to
That's where I
the
was.
jury, including the use of the jury questionnaire, I had, at the request of the parties and with the consent of all parties, sealed or continued the seal on all of these documents, and the previous order indicated that everything would be unsealed either November 30th or at the conclusion of the jury trial, whichever came first. Of course, the jury trial is now concluded, even though the case hasn't gone to sentencing. So my intent would be to unseal everything tomorrow, unless you have an objection and it's based in law.
BOA Bands
I-
of America.
Like you said, this
Bands
month,
Over America. One of the two.
I didn't even know that this was even sent over to.
Well,
the
now
jail
you
until
know.
Right now, until
Read
you
it.
told me.
Understood. Do you have an objection to what I propose to do?
Okay, now
I
you
don't
know.
even understand. What do you mean by sealed and unsealed?
Ask your
It
lawyer.
would become a matter of the public record, and anyone could review those search warrants.
Me.
If they make a request.
Search warrants for what property?
There's a number of search warrants.
Sir,
that
you
have
know
been
what a search
sealed
warrant is.
as it relates to this case.
Sir.
From what I saw, everything's been pretty much public.
Blair, it would have been procedural at this
I don't
point
see
based on the
why they need to
conviction.
be unsealed at this
No
point.
behavior on his part. It would have just been the
Everything's Pretty
conviction.
much been public already.
Yep. So no objection.
All right, well, I am going to unseal them effective
There we go.
tomorrow. The clerk's office is instructed that first thing tomorrow morning, they may unseal all of the search warrants in this case. The next issue I want to address is I want to make a record specifically as it relates to the restraints
Because of
that the
his
Sheriff's
statement.
Department utilized during this case, given a comment made by Mr. Brooks when the jury was
No
coming out
chaos,
the very
Rob.
last time. I don't recall if you said something about a stun belt.
You said
or,
shock. Can I take these
shock,
shocks off?
shackles or something to that effect, but it was inaccurate. I have asked the Sheriff's Department to provide photographic documentation of the shackles that were utilized in this case. The parties will recall the tables look a little different now because there are no table skirts on them. On all defense tables in the secure courtroom, there is a ring It's really more looks like a rectangle that is attached to the leg of the table, and an inmate who's in custody but in trial, a soft restraint system is utilized.
He's
primarily
shackled to
so
the
it's
table.
soft and not heard. And then it's attached to the table so that it confines the inmate.
So soft
to
restraint so you
a
can't
small
hear
area
the
with that
jingling.
table. Obviously, during the trial, Mr. Brooks was able to stand. His hands were free, but I felt it important to have a thorough record of the restraints that were utilized. The photographs that have been provided are on a compact disc. They will be filed as Court Exhibit 3.
She's
they
being
will
very
remain under
careful.
seal. And that is because of the security concerns related to how the Sheriff's Department secures inmates during a trial. That certainly is an overriding interest, overriding any public interest to see what those restraints are.
He did say,
And I would just further note that during the trial, when Mr. Brooks would be brought from the holding area into the courtroom, this courtroom was closed to the public. And that was really to maintain that privacy, if you will, or secrecy, if you will, regarding the restraint system. And so I believe it's important that that information not be released to the public. It will be available, of course, to the court and the parties. And if there is an appeal, any attorney that may represent you can certainly look at that, but it'll otherwise be under seal. So
Why would
the
that-
record is very clear on the restraint system.
'Cause you
that was
said
utilized
it.
during this trial.
because you
I have
brought
a
it up.
question to that.
You
Okay.
said it.
Why is that remaining sealed, but everything else being open to the public?
That's not sealed.
I've indicated my reasons are on the record. I'm not going to restate them. So
Well, I think that
She
the
just made a
public,
record.
If they're allowed to see search warrant information and things like that, then I think that they should know that it was a shock device on my ankles. That
there was no shock device.
It
on
was
your
a
ankle,
shock
sir.
device. I was told it was a shock device.
Mr. Brooks.
They might have lied
And
to you.
That's
it was
why I'm
covered
making
up.
the
It
record.
was covered up by a black cloth, so
They might have
the
lied to
jury
you.
purposely could not see it, and so that the public cannot see it. I was
That's
told
for
that a
your
chair
protection.
had to be placed on my side so that no one can see that I was
Shackled
shackled with
to the
ankle
table.
shocks.
They
I think
weren't
the public
shocks.
should know that. The jury should have known that.
No.
That's what they were.
Mr. Brooks, I've made my ruling. Your
I
characterization
respect your
of
ruling,
those
but it
as-
should be
Hold on.
noted.
Your
it should be
objection is
noted.
noted for the record.
It
Your-
should be noted that I had a shock device on
You
my
did
ankles.
not.
That's
She's
fact.
saying that he didn't.
It
It's
is
a
not
fact.
sir.
It is a fact. I'm the one that had them on my ankles. I inquired about what they were. Obviously, I'm going to inquire about what's being put on my body. I was told that they were a shock device, which I know how a shock device looks because I've been through this before in Milwaukee. So I know what a shock device is. It was clearly a shock device that was purposely not shown to the jury or to the public. Purposely not. And then now you're saying
That's
that
for
it's
your
gonna be
protection.
sealed. Well, why should it be sealed? The
All right,
public
Mr.
says
Brooks,
deserve-
you're-
Public
the
interest.
deserves
You've
to
made
know-
a record
the
and
public
it's
deserves
noted.
to
No.
know about
And
things pertaining to
He's
a
been
search
convicted.
warrant, but
She's
not the
allowed
fact
to
that
be
I was
more stern
limited
with
by a
him.
shock device, that if I moved the wrong way, I could have got shocked with all this
it's
voltage.
absolutely false that you
That
have a
is
shock
not
device
false,
on,
and
sir.
you know that it's not false.
Well, I have the photograph.
Well, show
that
the
will be
photo. Where's
part
the
of the record.
photographs? Where's the photograph?
This is what he's mad
And
about.
they
This is
will
what
be
he's
Just
mad
said
about.
it's sealed. Why do they need
From
to be
public
sealed?
view
Why
for
do
the
they need to
reasons
be
that I've
sealed from
already
the public?
indicated.
Why do they need to be sealed
Mr.
from
Brooks,
the
I
public?
need to move on to scheduling.
Can we move on to subject matter jurisdiction?
There
Has
it
been approved
is.
For the record.
All right.
There
so
it is.
Move on to that.
Mr.
There it
Brooks,
is. How
I
many
don't
minutes are
wanna
we
remove
in?
you from the courtroom today.
It-
But
I,
I need
11
to move
minutes.
on.
want to be removed, but you're
11
not gonna
minutes
sit
in.
here and tell me on the record what was on my body when I was told what it was. That's inaccurate, and I refuse.
At a
Your
later
Honor,
point in time, I
Your
will
Honor,
put.
I refuse to sit here and let you make an inaccurate record when you know that it was in fact a shock device. That's why I had the black cloth in front of the table,
No.
so it couldn't be shown.
That's
That's why I
Shackles.
had a chair sitting on the side of me that was told
For the
used
shackles.
to cover up the fact that I had a shock device.
That you had
on my
shackles.
And I think it's very, very, very unfair.
Just let him make the record at
and
this
it's
point.
dishonorable to get on the record and not tell the truth.
Dishonorable.
I'm not trying to dishonor you, Your Honor. I'm not trying to disrespect you. I'm not trying to disrespect your court. I just want the truth to be told.
Fair.
That should not be sealed. If
The record
everything
is
else
so
can be
marked.
open to the public,
Move on.
then the public should know that I had a shock device on my ankle.
They can't.
That was
'cause you
purposely
didn't.
not shown to the jury or to the public. They should know that.
All right, thank you, Mr. Brooks. I disagree wholeheartedly.
Your
with
record
your
has been made.
It's not
characterization.
true.
Mr. Brooks, I didn't interrupt you. Please
It's not
don't
true.
interrupt me.
It's not true.
Mr. Brooks?
I'm quite sure
Bruh.
there's cameras rolling right now because there are always cameras rolling. There's always audio on.
Mr. Brooks,
We
I
can
need to
hear
move
you.
on to
There's public in the
scheduling.
courtroom. I had a shock device on my ankles. And
You
they
said what-
purposely did not want to show that to you guys or to the jury.
Oh, now he's aware of the cameras.
That's
Mr.
why I
Brooks,
can only
Now
I'm
he's aware of the
advising
cameras.
you-
Here
Now he's aware of the
or
cameras.
here.
Mr.
That's
Brooks,
the
I'm
reason why.
advising you.
And I always had the chair right here.
Don't
Everybody
advise
that
him of
came to the
shit.
courtroom seen that I had a chair right here, even though I had no counsel.
Your record's
What
been
is the
made.
reason for me to have a chair right
All
here?
right, Mr. Brooks.
Your record's
any
been made.
further-
Black cloth
Any
in front of
further
the table.
interruptions will result in you being removed to the other courtroom
Okay,
because
and
you're
you
not
hold
letting
me in
move
contempt,
on to
that's okay.
scheduling.
Is it civil contempt or criminal contempt?
One
You're
more
not-
interruption and you will go to the other courtroom.
Oh my
They
God.
need to know that.
Stop.
They need to know that. They need to know the
Stop.
I'm going to ask the state some questions. If you interrupt when I do that, you will be removed to the other
Okay,
courtroom.
remove me
Oh,
All right,
Jesus.
then. Remove me then.
Don't remove him.
Attorney
Just
Basie.
get
It's not
through
gonna stop the
this.
fact that they need
All
to know that a
right,
shock device
he's
was on my
interrupted.
ankles.
I'm sorry, everyone. We'll have to clear the courtroom. He will be
Ah!
moved to the other courtroom. I'll
That's
make the
fine.
appropriate
Tell the
findings.
truth, though, Your Honor. Tell the
No, I
truth. I had
like
a shackle.
Captain,
I had a shock device
Captain,
on
A
my
we're
ankles.
shackle.
see you. We're off.
Damn it. I should have put up a poll about whether he'd be removed. I honestly didn't think he would, but this is just clearly he is triggered by the fact that the court made a record. The reason the court, I guess it'll be what, 5-10 minutes. The reason the court made a record is because as the jury was coming out with the verdict, he said, "Can I get these shock devices off me?" where jurors could have heard him. The court has made a record today saying that there was no shock device on him. He was shackled to the table in soft restraints. The soft restraints are like more of a leather cuff with a buckle that isn't going to be heard like rattling against the table like a metal on metal, and that the jury is not going to know. The jury shouldn't know he's being restrained for his protection. There is case law. There is, lots of case law, jurisdiction by jurisdiction, but showing him shackled to the table tells the jury what? This is a dangerous criminal who can't be in the courtroom unshackled from the table. That can bias or prejudice a jury, even subconsciously, that he is guilty. Because obviously, if the concern is that if he's shackled to a table, then he is obviously dangerous. Therefore, he should be considered guilty. He has a right to an impartial jury and a fair trial. So they can't see that. And that's the point of making sure that there was a cloth around the table so they didn't see he was restrained, so that he could stand up, so that he could move around. This is all to not bias the jury in favor of finding guilt, so they're not considering things other than what the evidence shows. It's to protect his rights and to protect the appearance of him to the jury. That's the whole point. But now he's triggered about that, and I'm sure the judge didn't think he was going to be triggered about that. Some of you have noticed or noted that the judge's mask is down. There's no more jury she has to keep a neutral face in front of. He's been convicted. She can just let the bitch face fly with the "I am so done with you." She can just let it be there. She can just let it be there. She can let her thoughts emote across her face a little bit more than she did now that he's been convicted. So he's now being removed to the other courtroom. There's over 20,000 of you here. Don't forget to do the YouTube, likey, subscribe, all the things. I'm going to get to some questions. Yep. Shima, he's been yeeted to the other courtroom. We got 11 minutes in. He mentioned subject matter jurisdiction and then was yeeted. So it's off. It's a busy one. Joshua says, "Happy Halloween afternoon, everyone. Wishing all of you a wonderful and safe day to everyone. Love all your content, Emily. Thank you. I wish a safe day to my children as I try to steal." No, I bought my own candy this year. I'm not stealing my kids' candy. I bought my own. Tired Mom has been my costume 3 years in a row. Glad I'm not the only one. I've got nothing this year. There was a very cool Halloween party that I was invited to in California for the weekend, and I am still bummed that I couldn't go, but we had a band competition. My kid's only in high school for 4 years, so so band competition it was. But let me tell you, the FOMO was real when I started seeing the pictures of other content creators that I very much like at the Halloween party. I was very sad. What's your over under on years for Brooks? All. I mean, it's all. I'm not going to, it just feels a little, I have a fairly dark sense of humor, but it's going to be all the years. The thing that's sad is no matter what they sentence him to, it's not going to change what he did. It's not going to change the damage done to the community. He's never getting out of prison. Hey, EDB from the Space Coast. I watch every minute of this trial. So glad to get to this phase. I'm sure everyone is. This trial went pretty fast, all things considered. Is there a link for your earrings? No, they're just Kendra Scott. They're like this Sophie or something. I love this shape. I also love a hoop, but this shape is so much easier for streaming because it doesn't hit my, like the wires for my in-ear monitors and stuff like that. So thank you. Quick question from Morgana. Hi, Emily. Quick question. How do you think he will be handled in prison? I imagine that for a while, depending on where he's housed, he will be kept separate from others.
Mr. Brooks, if you interrupt me, I will mute you so that I can make an adequate record regarding.
Anyway, Your Honor.
All right, he interrupted. I will mute him. I need to make a record.
You're going to mute me anyway. Mute.
The court did warn Mr. Brooks repeatedly that if he continued to be disruptive, the court would remove him to the other courtroom. It was my sincere hope that that would not need to take place today. I gave him the final warning, and then I indicated I would be turning to the state to ask them some questions. And if he interrupted that process, he would be removed. He immediately interrupted that. And so the courtroom was closed. He was put into the other courtroom. I have confirmed that the audio and visual technology is working. He can hear, he can see, at least the other individuals in there confirmed that that was the case. He was audible for a little bit when I first went on the record, but he continued to be disruptive. And so I did utilize the mute function of the technology so that I could make an adequate record. Although this is really a scheduling hearing today, I will make a finding under Illinois versus Allen that his conduct was did disregard the elementary standards of proper conduct of decorum and courtesy. He was disruptive. He interrupted multiple times and challenged this court when this court was making a record regarding the restraints that were utilized throughout this trial. I'm not going to do it today, but I will at a later point in time. Perhaps after scheduling, I will have a deputy testify regarding the restraints that were utilized so that there is a full and complete record about what was utilized and what was not utilized throughout this trial. It is absolutely false that a stun belt of any kind was used on Mr. Brooks. I don't know if he's receiving that information from other inmates.
Possibly.
But that was not utilized in this case. It was a soft leg restraint
shackle
setup, if you will, where he was shackled his ankles with the soft restraints and the soft strap so that it did not make noise. That was all attached to the
They've been so
table.
Considerate this trial.
And it is absolutely true that there was a black table skirt on the tables, both the state's table, the defense table in this courtroom, despite Mr. Brooks believing that it was not done for his benefit. It was to shield that information from the jury. It's also true that at all times when he has been brought into court, it's been before the court has been open to the public. If this court needed to remove him to the other courtroom, it was also done with the courtroom closed to the public. That was, of course, a security decision made by the sheriff's department. They are in charge of his security as well as the court's security during any court proceeding in this courthouse. And it was their discretion and decision on what restraints would be utilized. And again, I'll go through that later and have a record made of what was utilized, including having one of the deputies identify what's on the exhibit. I'm not going to show that publicly. Again, there are security reasons. We don't, frankly.
He's in time. He's in the timeout box.
Doing research.
He's in the penalty box.
Doing research on what these restraints are. There's an important security aspect related to keeping courts safe, keeping inmates safe, and that is why I'm sealing that information from public view so that their protocols and practices have that, frankly, veil of secrecy. It's important given the security issues. It's a law enforcement function, and that is my decision on that.
You don't need to let the
As
public
far
know exactly
as,
what type of
Mr.
shackles
Brooks
are being
being in
used
the
because
other
they can plan
courtroom,
how to
Again, I
evade
did
them.
that pursuant to the authority found in Illinois versus Allen.
Manny, today they are deciding when his sentencing will be and how
Briefly,
long it will
because it's
take.
a scheduling type hearing.
How many hours or days?
I could simply have him taken back to the jail and he could appear by phone, but I've chosen to have him appear by video and audio means from the other courtroom. With that, I am going to address scheduling. I will be asking each party in turn how much time they believe they need to present their various sentencing remarks and whether anyone will be speaking on behalf. So I'll turn to the state first.
Thank you, Your Honor. To date, we have indications from the victims or their families that 36 people would like
Oh, that's a
to
lot.
either have a statement read or they'd like to read it themselves. We have approximately 5 to 10 others that would like to submit one in writing, which obviously wouldn't impact the time that we would need on the sentencing date. I would think that the state's comments would be between a half an hour to 45 minutes in total. So we're looking probably at about 4 to 4.5 hours. We will need some time to rotate victims out of the courtroom.
Yeah, that's going to be 6 hours that
as
you
they
need
come
to
in
set aside.
to speak, because we can't fit everyone in the courtroom at one time. So we'll need to get one set in, get another one to room 115 so that they can hear what's being said. So we're thinking 4 hours, and speaking with the families and the victims Wednesday after the verdict. I think there's a strong desire to have the sentencing before the anniversary of the parade incident, and that obviously is November 21st. In checking with people, November 15th, 16th works for everyone. Specifically, the 16th works for everyone that would like to talk. I know that this court obviously has court calendars. I do have other dates that would work. Unfortunately,
This is for impact statements.
To the end of December, end of November, beginning of December.
I like that they cleared it with everyone who wants to speak.
I can't emphasize enough. There are a lot of families who are leaving town the week of the parade
for the anniversary.
And I think the general consensus would be, it would be nice for them to have some finality to this before they leave, so that they're not around here at the time that a loved one was injured or killed.
By any chance, did you have an opportunity to look at my calendar and some of the jury trials and talk with your colleagues? I mean, one of the cases, for example, I have on the 15th is an attempted homicide trial. I don't know if that's going to go or not, but
did you talk to the other DAs?
This court gave due attention to this case. I need to be mindful that that case has been scheduled since June.
Yeah.
I did not. I received these dates,
but I'm their boss.
That they were
so
probably sent this weekend. I did not check my email over the weekend, so I did receive them this morning, and unfortunately, I did not take the time to do that.
The bosses will just make it work. They're the bosses. It will just.
We can certainly look right now.
They'll make it work.
Do you know who's handling that attempted homicide from our office?
I believe that's Attorney Sitzberger.
Okay.
Yeah, we
There's
can.
Other cases as well.
It's gonna be fine.
It's rare that I wouldn't stack trials, and so there's also
stacks of trials.
Another serious felony matter with Attorney Thurston for your office.
The thing is, these are all DA matters.
Scheduled in August.
The DA's office will be able to clear room for sentencing, even if a jury has to recess for the day. I imagine any jury in the area will understand that
another one with you.
The sentencing needs to get done.
I'm just looking at the number of.
So what has happened is this judge was in trial for 3 weeks. So everything literally stacks up behind it and has to get done.
8 different
and it gets very busy.
Many more cases, but 8 different defendants scheduled for jury trial.
For trial.
On the 15th. The other thing is on the 16th.
They have 8 jury trials scheduled the 15th.
It's a very special meeting. I'm still the chair of that, and that is an anniversary of the CJCC that I do not want to miss. So not that I couldn't work around that, and it's not that I'm not willing to change,
so court scheduling is very difficult.
I can tell you, Attorney Witchow did reach out to Attorney Sitzberger. He indicated and he said we could put this on the record. He's 98% confident that that will resolve, the attempted homicide will resolve. Attorney Thurston is not in the office today, so I can't speak to that trial.
A lot of trials do resolve. That's why there's 8 on a day, but it can be accommodated and worked around even if they need to take a break.
Right,
But
let me,
it's very
before we
busy
look at
before
dates,
Thanksgiving
of course, let me
to
talk
try to get
with
cases done before the end of the
Mr.
year.
Brooks and find out
What his
how long
schedule
he
is?
Anticipates his sentence.
He's
and
around.
and whether anyone. So, sir, I have unmuted you. If you could speak to scheduling.
But he has family.
First, Your Honor, I would just like to say that
Subject matter jurisdiction hasn't been proven for the record.
I know you're well aware that I have ongoing matters in Milwaukee pending too. I have to be in court there in 2 weeks, and those cases are scheduled for trial as well.
They can work with that too.
I haven't had the opportunity to speak with my representation over there because of the protocol that I've been on. These
That's
past,
fair.
I think it was 5 days since I last was in your court.
I forgot he had.
I would like the opportunity to.
I forgot he had other cases in Milwaukee.
Now that obviously this was the big case, obviously.
Yeah, the other ones will resolve because you're going to go to
If it
prison for
pleases the
life.
court, if it pleases you, Your Honor, I would at least like to get a disposition on what might happen there. I go to court there in 2 weeks. I'm sure that I would learn a lot more at that time. I'm not sure if I'm going to have the same representation at this point or if something's going to change with that.
What, you want to represent yourself again? You liked this
The
experience?
specific date that you're scheduled?
Yeah. When are you in court,
The
sir?
17th.
Oh, then you can get
where
sentenced
both
the 16th.
cases stay. I don't know why they put
Transportation.
both cases on the same date.
So they don't have to
And like I said, I don't
deal with
know
it.
if anything's going to change between now and then. But both of those cases are scheduled to go to trial.
Those are
And like I said, with the representation there, I don't know what's going to happen with that as of yet. There's
he has a lawyer there.
issues for months with that. I know that's
Oh, he wants to represent
something that
himself again.
Milwaukee has to deal with,
Sir.
and not your court. But it would be a great help to me to at least be able to find out what I can find out about what can possibly happen there.
See if you had an attorney.
To also do any work that I may need to do on my end.
Your
prepare for
attorney.
that.
And the other attorneys could talk.
So I have looked at the
Then
dates.
those things would
You
be
are right.
resolved.
There's a hearing on the 17th at 2 p.m. The trial, though, in that case is not scheduled until December 12th. So my belief would be I could certainly see the judge in that case understanding if we had to go to sentencing or I chose
Yep.
to go to sentencing on those dates.
They could bump his hearing a week. It
Like,
wouldn't be a
again,
problem.
both cases are scheduled for those same dates.
Yeah, it was kind of weird to me. I don't, the way they scheduled both cases on the same day was just kind of like, I didn't really understand why they did it like that.
So they don't have to bring you back and forth, dude.
And
Just to make it easy on everybody.
Well, let's
'Cause
talk
you
about
take up a lot of
related issue,
time.
and that is, do you anticipate anyone speaking on your behalf at the time of sentencing?
You are difficult.
I do.
All
I
right.
do.
And do you know how many people you anticipate speaking on your behalf?
I don't know an exact number, Your Honor. Rough estimate there be 20 or more.
Really?
I have not yet
Called anybody?
spoken with everybody, obviously, because of the protocol that I've been on.
That's
I
fair.
haven't had the chance to. Essentially, some people will be traveling to Wisconsin from different areas.
Your
different
lawyer could make
states.
those calls. Oh, wait.
And I know they've expressed wanting to be there to speak for that. But like I said, me, myself, not being able to have the opportunity to speak with them personally,
That's what your lawyer's for.
I don't know exactly how many. And I don't know how many people will be coming from different parts of the states. I would ask, if it pleases Your Honor, to be able to have everyone that does want to speak and does want to address the court, to give them the opportunity to be here for that. I know there's as far as the people that are here in Wisconsin that will speak, one thing that they was stressed to me is that how is everything going to affect what's going on in Milwaukee? So that was like one thing that came up, and because I had totally forgot that the Milwaukee court dates were this close. And
It
so
makes
I was
it
just
easier
like,
for
yeah,
those
you're
cases
right,
to plea.
17th, that's 2 weeks roughly.
Because
I don't know exactly where we're at in those proceedings. Like I said, there's still like some issues going on with the representation. I haven't been able to reach out. Obviously, I can't reach out from where I'm at, collect call wise. And
yes, you can.
I've had very limited interaction with the current representation in those matters. So I don't know what pleases you, Your Honor. I don't know what pleases the court, but I guess what I'm seeking is
More
for
time.
enough time to know exactly who's going to be speaking, where they're going to be traveling from, and
This is why you have a lawyer. This is why you have a
a little
lawyer.
bit more information that I can provide to this court about the proceedings in Milwaukee County.
One of the things that I've done for other cases, and I know I was asked about this previously
To allow
as well,
Zoom.
and I would also offer it up to the parties, is I will also make available Zoom for
Yeah.
victims, family members, including your family members, who would like to make
If they can't travel.
a statement on your behalf. The only thing I ask, though, is I'm not just going to open up my Zoom to anybody. And so anyone who wants
I wouldn't.
a
Pre-approval.
relative, a victim, family member to speak, whether it be from the state or from you, Mr. Brooks, is I need to know who, no later than
5
a
days.
couple of days before. I'm leaning toward scheduling this on the 15th, so that would be like the Friday before, which would be the 11th, so that
We're good. We're good the 15th,
when they
16th, Your
come
Honor.
on the
We'd like
Zoom,
this
they're
date.
identified, and then I let them
Law and
in.
order to prove.
So I understand your concern about the Milwaukee, but if I hold this on the 15th and the 16th, by your description of how many people, by what the state said, I think it's going to take about a day to hear the remarks from the parties.
Yep.
And then I would come fresh the next day to give the court's sentencing.
That's fair.
And so probably a day and a half, but I'd set aside
Works for us,
both
Your
of
Honor.
those days just to be on the safe side.
Yep. Good.
In case it takes a little bit longer.
We'll all get a
either
fresh
of the
blowout
parties
in
to
honor of your
present their
hair.
Sentencing remarks.
We're here for it.
Your Honor, I'm not interrupting.
Go ahead. Go ahead.
I
Thank
was
you.
trying to make sure I didn't interrupt you.
Now we're accommodating. It's amazing.
Your Honor, with all due respect, if it pleases the court, if it pleases your court, Your Honor.
What pleases her is the 15th.
Because of my situation, I could benefit from a little bit more time. I'm not asking for something outrageous here. Just enough that I can tie up some of my loose ends, get you the information that you need to be able, if someone has to be present by Zoom or whatever the case may be, or to find out if these people are actually going to travel.
He's polite because he wants something.
Be able to prepare for what I need to prepare for.
He's polite because he wants something.
Regardless to anything, I still have to be prepared.
He's trying to get his way.
To continue court proceedings, I still have to be prepared. It will really be a big help and a great benefit if I can have just a little bit more time to tie up the loose ends and get everything done in a timely fashion to be able to be ready to go and present what's needed to the court.
Because you were so accommodating.
I understand that, sir. The issue the court has.
You helped the court so much, sir.
Obviously, if I wait much longer than that, I would, out of respect for the victims, avoid the
holidays.
week of November 21st. That's also Thanksgiving week. I don't think that would be an appropriate time for sentencing. But then
it would not.
After that, I do have, my calendar is just incredibly full.
Of course it is.
I have some time off in there.
Of course you do.
I have trials almost every week other than the week that I'm off, all the way up through the week of December 19th. And then
A break for the
I'm off
holidays.
again for the holidays. I wouldn't, and so that puts us into January, and I'm not willing to do that. It's just
Too
and
far.
Plus, I need to avoid the week of that trial in case one of your cases goes to trial.
Which they shouldn't.
So,
His other
I think
trials
I'm giving
should
the
plead, but
parties
he
ample
doesn't have
time.
to.
I'm giving alternate ways for family members to speak.
She's going to just set
And
the
that
dates.
is by
Good,
Zoom
set the dates.
or in
Set it.
person, should they wish to be here in person. And I'm willing to clear my calendar, even of those trials. Hopefully my trials resolve, but to the extent that they don't, then I
I'm going to
will
answer this
clear
when we take a break.
Tuesday the 15th.
Good.
Wednesday the 16th, though, I would not start until
He is
later
highly
that day, given
Manipulative
the
in his behavior.
meeting I have to chair for the Criminal Justice Coordinating Council, or Collaborating Council. So that's from 8:30 to 10. I need to talk with our executive director a little bit more because I know we have a special type of meeting schedule, and I don't know if it will go longer. At a minimum, it would be safe to say the afternoon on that date. And no matter what, that would still clear Mr. Brooks to be in Milwaukee
The 17th.
on the 17th. I mean, we're one county over. It's not unusual to do an order to produce that close.
What I was gonna, I'm sorry.
No, so
Now he wants
I am going
something.
to schedule it for the 15th and the 16th. The 15th will start at 8:30 a.m. And depending on, I'll be ready to go no matter what on the 15th. And if the state takes into the afternoon and then Mr. Brooks needs the rest of that afternoon or into the next day, I will certainly make those accommodations. I think I'm going to tentatively say we're going to schedule it for 1 p.m. on the 16th.
That works for us, Your
If
Honor.
anything changes, I'll let the parties know. And then I just need to know by Friday, the 11th at noon.
It's a
who
holiday.
The parties are asking, make their statements by Zoom with a listing of their names so that
This is how
when they
she's limiting
appear
it,
on the
Rob.
Zoom, because then we'll release
Advance
and I'll
notice.
prove it.
That's the
We'll
limit.
release the Zoom information.
She's giving him an
I need
opportunity.
everyone to be aware, though, including victims, you may not, your family members, and it may not just simply give this Zoom information out. It will be only for those individuals that are identified by the state as wanting to appear by Zoom. I want to keep a tight control over that.
It's going to be streaming. They
And
don't
if I
need to call
don't
into the
see,
Zoom.
Like a name either says a name that's been approved, like let's say you had a friend by the name of John Smith. If John Smith doesn't say put on their Zoom info, John Smith.
Yeah, if they
I'm not-
screwed up.
and it's just a phone number, I may not let them in.
Say
Have
will
to be
not.
Identified, can't just give it out to anyone. And it's only for those individuals who want to make a statement, since the proceedings will be live streamed as well.
We will be
whether that
here.
be how we've been doing it throughout the trial, or if I utilize the Zoom and the live stream I've done in the past, so that other people can watch it as well.
We will be doing it whatever.
Courtroom that we have. So
I'm sure Court TV will be
that's my
here.
decision on that.
Great. Moving on.
And at the
Great.
I want to just very briefly have, I believe it's going to be Deputy Kibler who's going to testify about the restraints.
There's testimony about the restraints to make a record.
Your Honor,
Yes.
but I'm not trying to interrupt.
You didn't interrupt. Keep going.
Go ahead.
We've moved on.
You said, when is this supposed to be? Because I'm definitely gonna need a little bit more time than the 11th.
No,
Mr. Brooks, I've made my decision. The sentencing will be on the 15th and the 16th.
you've
of
got more than 10
November.
days, sir.
Anyone who wants to appear by Zoom on your behalf, you must file a request in writing no later than noon on the 11th. The
Ask
same
your
is
lawyer
true
for
the
help.
State. Everyone needs to be specifically identified so that I can make the appropriate approvals. And only those individuals who I specifically approve to appear by Zoom may be on the Zoom. The Zoom information
And
can't
that is
be
it.
passed out further. And I'll create a special Zoom for that, and I'll make sure that I work with Teresa to do that and get that information when I approve that to the parties.
Moving
Your Honor,
on.
what if I'm placed on the protocol per the jail?
That's unfortunate.
What if-
Mr. Brooks, that's between you and the jail at this point. If there is something
Your lawyer could help with.
you need to first go through them. I'm not going to step on their toes with their protocols. I'm sure they'll understand this is a very important sentencing for you and make certain accommodations. They've done that throughout this case. I trust that they will do that as they determine.
Sir, there's nothing you can do that's going to change
They
this
haven't done it
sentencing.
for the past week when I went on the protocol without even telling them anything suicidal in nature, and I was still placed on a suicide watch protocol.
I understand that, sir. I need to move on
Because
I
of
do
your
have calendar
conviction.
this afternoon, but I want to have Detective Kibler come to the stand.
Your
Kibler.
Honor,
Deputy,
What?
what did I say? Detective, did I give you a promotion? Sorry. All right.
Promoted.
He's gonna come on up to the
Moving
witness
on.
stand. I'm gonna
But-
swear him in.
Nope, no, hold
and,
on.
We'll go.
She's just going to mute him. There's no holding
For the
on.
record, may I respectfully object to your ruling, Your Honor?
Sure.
Noted for the record. All right.
We're
have
moving
him
on.
Swear him in, please.
For the record, may I respectfully request a legal reconsideration
All right,
of your
Mr.
ruling,
Brooks,
Your
I'm gonna
Honor?
have to mute you. 'cause I
Denied.
need to keep going and I can't have this disruption.
I
Go
can't
ahead.
have you just
Raise your right
talking.
hand.
Do you solemnly swear that the testimony
He
you
doesn't
have
realize that
is
he has
the
been
truth,
convicted
nothing but the truth, so help
and
you
that
God?
his schedule is not what's
All right,
important.
thank you, sir.
here.
Have a seat.
All right, we have a
I'll
witness.
let you put your name on the record so I don't get that wrong. And so go ahead. Please state and spell your first and last names.
First name Nicholas, Nicholas. Last name Kibler, Kibler.
This is regarding the
All right,
restraints.
thank you. And you are employed in what capacity with the
It's a whole
sheriff's
bunch of a
department?
hearing.
I'm a deputy for the Waukesha County Sheriff's Department.
I don't think so. I don't.
What is happening?
All right, sir, were you assigned to the trial of Darrell Brooks?
I was.
And can you tell us in what capacity?
My capacity was specifically, my responsibility was Darrell Brooks, along with Deputy Stenielson.
And
And-
were you in court at the start of the trial on October 3rd?
I was.
And did you come into court or work the court trial every day that we were in session?
I did.
And can you, were you at all in charge of the restraints? Let me ask you this, do you have knowledge of the restraints that were utilized on Mr. Brooks
I
throughout this
do.
trial? Can you describe those, please?
It's a soft restraint that we used. It was not any type of electronic control device. It was just a soft restraint that we applied to Mr. Brooks
There you go.
prior to coming into court every day.
And would that be a restraint system that was on his legs or something else?
It was around his ankles.
All right. Throughout the trial, the tables in this courtroom had black table skirts. Do you remember seeing those?
I do.
And did that hide from view in any way the use of the restraints from the jury?
The judge is just making a
I did.
record because of what Brooks has been
And
saying.
were the restraints
appeal.
also attached to the table in some fashion?
They were attached to the table by a tether.
At any point in time, were there any other restraints utilized in the courtroom?
There was not.
At any point in time, were there any type of electronic or stun device placed on Mr. Brooks?
There was not.
The judge is making a record. We had all heard that he had shocks on. I don't know where that rumor started from. Also, he might have thought
Anything
that, and they
you
might
would
have
like to
not
add to the
disabused him
record
of that
regarding the restraints
misinformation.
that
They
were
might have let
used?
him think that.
Not at this time.
So you
Which
have any
is-
questions?
They're allowed to just let him think that.
Sir, you indicated that the restraints were connected to the table through a tether, is that correct?
Correct. And then we would secure them with a padlock.
And how
On the
long was that
restraint.
tether?
The tether that was in here was 4 feet.
So he could
So
stand
Mr.
up.
Brooks could stand up?
Correct.
He could walk to his left briefly and walk to his right, is
He-
that correct?
That's correct.
And that was the same rule that the state had, that we had to stand up and use our table to question witnesses. That was the same
He
rule
doesn't know
that
that.
applied to Mr. Brooks.
Correct.
Nothing further.
I would want this question
Mr.
asked
Brooks, you're
too.
muted. Do you have any questions regarding?
they
the
tell him?
restraint system
I would want to know that.
as testified to by
Yes.
Deputy
Yes,
Kibler?
yes, I do. And Your Honor, you can't practice law from the bench.
Your question, sir?
Sir, she's the
So-
judge.
None of your fellow deputies told me that it was a shock device when I asked what was being placed on my ankles at the start of this trial.
Not that I'm aware of.
Good. There we
Not
go.
that
That's the
you're
question we
aware of.
wanted.
Do you know for sure that I was told that they were a shock device?
I don't believe that's the truth. I believe every time you had those devices put on, I was in there, and it was either myself or Deputy Stenielson putting them on, and I did not tell you that, nor did I ever hear Deputy Stenielson tell you that they were an electronic device.
So you were here every single day for every single moment of the trial.
Correct.
And
What
you
a
never
joy for
heard
him.
Any deputy tell me that they were. Matter of fact, let me back up. Do you recall me asking what was being placed on my ankles?
That I don't. If you did, we would have told you it was just an ankle restraint.
He doesn't remember you ever asking, Brooks.
And you said that it was an ankle restraint. Did it have any metal parts?
Yes.
And what are those
Look.
metal parts?
Metal part is where a strap
The
went
buckle.
through and the locking device.
Just answering what's asked.
And what are those?
Because trained.
Let's say if a defendant in a trial attempts to, let's say, attack someone, what would be the purpose of those ankle restraints?
The restraints we had on you would limit your movement. So if you did try to do anything, we
You
would have
can't
had
move.
enough time to
Get you.
control you.
And you state that
The shocking device would have come out of their belt at that
Well,
point, not from the table.
the prosecutors stated that the same rules were in effect.
Amy, I
for
think
the
actually
defendant
these
as
are
the
fair
prosecution,
questions.
But were they not
He doesn't ask
allowed
them.
to put up exhibits to go to the
That's outside the scope.
front of the courtroom and put up exhibits?
That's outside the
They
scope.
might have a few times, but
The record will reflect it was one time
That's outside the
in the
scope.
presence of the jury. And after that, I called them on it and said that would not happen. And then after that, it was only with the permission of the court and then outside the presence of the jury.
They went above and beyond to not show that he was
I don't
limited to the
believe
table.
that, Your Honor, you could practice law from the bench and answer the question that was asked to the.
She's making
Mr.
a
Brooks,
record.
I'm in charge of the record, not you, and the record's going
I
to
didn't
be
say I was-
accurate.
I didn't say, well, it's not accurate. You're practicing law from the bench.
All right, Mr. Brooks, do you have any other
Sir.
questions for this?
Yes, I
witness?
do. Yes,
All right,
I do.
it has
Mr.
to
I'm
be
in
about
charge.
the restraint system. Please
Okay,
continue.
and was I allowed to approach the bench and put up exhibits at any time during this trial?
you
No.
were not.
And so
Woo.
how is it that the prosecution was able to do something that I was not able to?
That's
do?
been asked and
That's
answered.
not for me to answer.
It's because of the shock device that was put on my ankle.
There was no shock device.
There was no shock device on your ankle, sir.
I love it when the judge is like, sir,
I was
false.
told that it was. And you said that you don't recall hearing that being told to me, correct?
No, it was not told to you by me.
I wonder if one of the inmates told him.
Yeah, by you, but you also said that's the point that I'm getting at. I'm asking the question. You said
I'm asking the
that it
questions.
wasn't told to me by you. I never asked you, correct?
You never asked me, but I also did not ever hear Deputy Stenielson tell you that they were a shock
I
device.
never asked you. I never asked you, yes or no.
No, you did not.
His lawyer
So
would have
do
been
you
able to
know
clear all
for
this
sure
up
if
for
I ever
him.
asked any other deputy?
Well, considering I was in there when the restraints were being placed on you
Every day.
I did not ever hear anybody while I was inside the bullpen
It's like,
while they were
this
putting restraints on you.
is what I had to do every
So
day.
it's fair to say that you don't know for sure if I ever asked what the device was that was being placed on my ankle.
No, I
Sir,
can't be for sure.
there's always a possibility that you asked someone else in custody.
So how do you know I didn't ask?
You don't have to answer that. That's argumentative.
It
I
also
mean-
assumes facts,
All right,
not
the
evidence. It's
record's
also
been made.
speculative.
Mr. Brooks, I'm
It is, it
cutting
is, it
off
is.
The questioning, I'm just muting him for a moment. The record's been made.
The trial's
Deputy, you
over.
may step down.
The trial's
Um,
over.
Mr.
The trial's
Brooks,
over.
If you
The verdict
have
is in.
additional information that
The
you want
record
to
is clear.
provide to the court, I'd ask that you do so in writing. And
It's
you
done.
provide the identity of any and all individuals you claim provided you with information that you were in a shock restraint. But I'll make a finding based upon the testimony of Deputy Kibler and also my knowledge of being in the courtroom every day and seeing Mr. Brooks being attached meaning they would secure him to the table, they would unsecure him when he needed to move and other things.
She's like, I watch this
Make a
go down
finding
every
that the
day.
soft restraint system was what was utilized, and at no time was he ever in a shock type of device. All right, with that then, ladies and gentlemen, it is going to conclude
And we're
the
done.
hearing today. We have the sentencing dates. I would also ask that any and all written material that
2
either
days of
side
2
wants
days of
this
sentencing.
court to consider also be filed by the 11th by noon. So that's November 11th at noon. That will give this court ample time to review it ahead of the hearing on
Their court might not
Tuesday,
be dark for Veterans Day,
November
to be fair.
15th.
I will
All right,
answer
thank
this
you, everyone.
as we rest.
We are in recess. The court's going to take a short break before I start with my remaining afternoon calendar.
All right. And that was just about an hour of hearing, including a witness. Y'all. And that's the end for today. So we have sentencing dates and times. Then we're going to go to Q&A, and then we will probably wrap up. I think we'll probably do an hour, maybe a little bit less of Q&A, because I still have to record a podcast today if it's going to get up on Wednesday. And we have a live stream tomorrow for Coffee and Cursey Words. So I'm going to get to as many questions as I can, and then we'll go from there. Thank you all for being here. There is over 23,000 of you combined on different platforms. If you're over on the Facebooks, don't forget to follow the page. Over here on the YouTube, don't forget to do the likey, subscribey, YouTubey thingies. And it's time to go. So this court has sentencing set for November 15th at 8:30 a.m. Central Standard Time. We will be here for that. And November 16th, starting in the afternoon, the judge has a conference. So the sentencing will be done before the anniversary of these killings. So with that, it is time to answer some questions. Let's see. Question: at his sentencing, when he said, "Can I get these shot cuffs off?" do you think that was for the jury to hear or for freedom of movement chance to run? I think it was for the jury to hear. I think he also might have thought that he was going to be freed. He was going to be innocent, but the jury had already made a decision. This happened when the jury was coming out with their verdicts. So I don't think it caused an issue that would be appealable. And the only appealable issue would be truly that it prejudiced the jury against the defendant. It wouldn't be it wouldn't be something other than that. It would be that this might make the jury think that he's guilty and might impede his perception or his presumption, not perception, his presumption of innocence because of the perception shackles give. So that's why they made such an extensive record, because he said it on the record and he kept saying shocks, and the court needed to be clear because shocks are a very different type of restraint. I had never heard of shock like ankle cuffs. I'd always heard of a shock belt that normally goes around the chest. That's a very different thing. It's used in limited and very specific circumstances, and much more of a record needs to be made. So I think the court, again, was clearing up the record. And my mods are giving me notes. I don't know why we're having problems with the way Darrell Brooks says asked or not, but with the AAVE, it doesn't really matter how he pronounces things. Look, I will never give him a hard time for how he pronounces things. I pronounce shit wrong literally all the time. It is his vernacular. I think there's a lot more to talk about with Brooks than how he pronounces asked. So it's not something that really is up for discussion. So y'all, thank you for being mindful, but making fun of him for how he pronounces something isn't law nerdy in the chat. Also, because I expect the same grace when I mispronounce shit, which is why we always give that grace. So thank you, mods, for letting me know. I didn't see it because I was starting to go through our starred questions. So do you think he really thought he could be found innocent? Yes. I think he thought his plea, to the jury would work. I think he thought that he could charm them and plead to their sympathies. And I think he thought it would work. Truly, I do. I think he thought it would work. It didn't. But I also don't know what he was going through mentally with this trial. I don't know why He thought that he could represent himself. I don't know why he thought that any of this was a good idea. But do I think he believed his own bullshit? Yes. I think he believed his own bullshit. I do. Tracy said, why would the jury care about his restraints? I wouldn't. I talked about this a little earlier in the stream. It gives a perception of guilt. If you see someone in a suit chained to a table, I think the subconscious perception is, oh shit, that person must be dangerous. Like in that courtroom setting, that's the perception, and that can go against the presumption of innocence. So when we go through it, we go through it. And Sherry said it's not a wrong pronunciation, it's different. Which is very fair too. I'm saying I'm not going to give him a hard time for using AAVE and using different vernacular. So because I expect grace when I mispronounce things or pronounce things differently. So that is completely fair. I'm not going to give him a hard time about it. And I expect the chat not to either, because I think well, we give dignity to all, even when it's difficult. And that is something that I expect, because there's just so much with Brooks. The way he says something is just not what I mean, not what bothers me. I think he was trying to endear himself to the jury. I think he thought that he would be granted a little bit more grace from the jury. So what are the odds of a bailiff tackle? He hasn't needed a bailiff tackle, though Brooks has absolutely run his mouth. He has absolutely shown his anger. He has pounded his fist at the table. He has used that aggressive stare down with the judge where he's tried to look, my opinion, tried to look menacing. He has not tried to physically upset the court. He has not tried to kick over chairs. He has not tried to flip tables. He has not tried to physically upset the court. He has absolutely run his mouth. He has absolutely been disruptive, but he has not been, table flipping of all of it. So with that, let us continue. Howdy, Lawnards. Emily, can I get a shout out to my new Lawnard friend, Lakin? They're a brand new fan of the legal drama. Of course, call me Al. Hello, Lakin. Thank you for the pronunciation guide as we were talking about the way I can't pronounce things. I'm rocking the Tired Mom Look Hard Ugly Monday. I mean, it was a long weekend. Judge Darrell coaches my daughter's volleyball team, and she's very awesome in real life as on the bench, if not even better. But JP, here's the real question that the chat, I think, wants and deserves to know. Does her hair always look good? Does her hair always look good? Because it's just, I can't. But I don't have thick hair. So those of us who don't have thick hair know the struggle. And we always look and go, I'm just a little jelly. Her hair is glorious all the time. All the time. So all the time. Question, are the jurors offered mental health services? If so, at whose expense? No, they're not. This is something I really would love to see discussed more in our system, but this would start me going down a rabbit hole on the way that we treat mental health in the United States. And that is not a rabbit hole that I am prepared to jump through today, but there is a much larger conversation about mental health care in the United States. But no, jurors, to my knowledge, are not offered mental health care. I have not seen that in any of the jurisdictions I've worked in. I have not heard about it in any of the jurisdictions I have friends that work in. I think jurors are going to need it after this and the things that they've seen. I always felt bad for jurors. Truly, depending on the case, depending on the things I had to show to prove my case, I felt bad. I really, truly felt for them. It's just, I'm sorry. I'm sorry that you're going to have to see this. It just is part of our system, but our legal system was built on transparency, ideally transparency, and being able to confront your accuser. So the jury's going to see everything that happened, and it's hard. So Electric Squirrel said it was so obvious he had to ask what it was. A masterclass in handling a gaslighter. The court did really well today, but again, this is after a conviction, which made it easier, I think, for the judge to just shut it down. So let's see. Anyone notice that the judge is completely over him? Yeah, the judge was absolutely over him today. Question, is she addressing the Reddit mess? She addressed it The night it happened. What night was it that we streamed for like 12 hours, Chad? I don't remember. Was that Thursday? Was it Wednesday? Was it Tuesday? Was it Monday? I don't know. Whenever last week that happened, she addressed it when it happened and then addressed the next day that they had said it was all a joke. Somebody posted an apology and then the entire subreddit got yeeted off the internet. Allie, thank you so much. I just wanted to say thank you for curating such a kind, healing, and safe space for nerds like myself. I left my PhD program today and entering substance abuse treatment. It's a scary endeavor, but this space has provided me a healthy escape to reality. Allie, congratulations. I'm sure this was a very, very difficult decision, a very hard decision. And I'm sure you will have tons of support here in getting the help that you need and continuing on that journey. If you don't already know my friend Peter Mon, go follow his channels, especially his Peterisms channel. He talks a lot about addiction and recovery and is just such an incredible human that might also provide just a safe space. So congratulations to you for making a very, very difficult decision. And I know you'll have lots of support in the chat. It's why when I ask what you're drinking, we always talk about the water too, because we have lots and lots of sober friends in this chat. Tech told me that Tuesday I streamed for 12 hours, so she addressed it Tuesday. So last stream on Tuesday, first stream on Wednesday is when we addressed the Reddit stuff. Allie is telling me it's Iona. Sorry, Allie. Thank you. I read it as an L. Because I did, because my brain does brain things. Anything for the last bits of theatrics also, hey. I think today, he definitely was aware of the cameras today. And he definitely looked to the cameras and was like, you need to know. I have shock belts, blah, 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 blah. But I don't know. I don't think he acted up that much more than any other day today. Truly. I truly didn't. Nuance is completely lost on him. Shocks, shackles, same. I truly wonder if someone in custody told him that those were shocks. I really do. And that if he brought it up, that the deputies didn't correct him. I don't know. I could absolutely see that happening. Lawn Lumber, 10 minutes in, lost that bet to myself. Also shock him, please. No shocking. He, just for running your mouth, you don't get shocked. Stop putting up with this BS. The amount I want to smack this guy. I mean, he's a little insufferable. Subject matter jurisdiction. Everybody hydrate yourselves. Hydration is key. I keep reminding myself. So it's dishonor, then dishonor on your family, dishonor on your cow, dishonor on your subject matter jurisdiction. That's exactly what it is. The dishonor on your cow is going to happen every single time he says dishonor. I approve of this message. I approve. Lawnards, I love seeing you send the support. I love seeing you send the support in the chat. That is what it is. And that is appropriate. Who cares if he has on shocks? Well, he did, and the judge had to make the record because it's very specific. Look, the authority of a court to shock someone when they're in court is substantially limited. You can't just run around shocking people. They're like taser shocks. So it is an extreme remedy, a very extreme remedy in court. And even having a shock collar on someone is an extreme remedy. So the court is very much making a specific finding. It's the same with gagging. Like a physical gag is an extreme remedy in court. They have a technological remedy where if he continues to interrupt, if he wasn't his own attorney, they could just remove him back into custody. They could just remove him back into the back. But this court has the technology to just mute him. It's a much less extreme remedy. So to take a 10-minute recess to put him in another courtroom where you can mute button him is a much less severe remedy than physically putting a gag on someone. So, and I think that that's appropriate. And I think, again, he is not making threats. He's disruptive, but he is not on the far ends and far bounds of defendant behavior in court. He's disruptive. So physically restraining him in that way doesn't seem appropriate to me in this case. He's turning court court into adult romper room. He definitely wants to get his way and he's not getting his way. And he just keeps talking until he can get his way. And sometimes it worked in this trial. There were times where he talked the court into reversing her decision. And we've seen lawyers do that too throughout the trials that you've watched streaming. You've seen the attorneys keep talking and the judge will alter their ruling. That's what he was doing. And I think for Brooks's personality, oh, I forgot to answer that. I think for Brooks's personality, being muted is probably more frustrating to him, truly, that she's just like, I'm not listening to you. Because he's like, you're going to listen to me. And she's like, you know what? No, I'm not. I'm not going to listen to you. So mute. The verdict had no merit to the restraint. He's fighting the wrong battle. He doesn't know that. He doesn't know that. So he's just, why didn't they just ask the bailiff if the ankle cuffs were shock cuffs? They had to clarify what they were. I think, this came in before they called the bailiff to the stand. So there we go. They did. Christmas tree like earrings before Thanksgiving. I wear these all the time, but I guess they do have a little Christmas tree vibe. I'm here for it. No, the court made the record. The law enforcement gave her evidence that he didn't have shock device. Yes, that's exactly what happened. Could he have had shock restraints and just say that he didn't? No, the deputy can't lie on the record. So no. I wish the judge would have just let him have. No. See, and again, the retribution is not where the judge should be coming from, even though sometimes it can be hard. So it's just he's going to be in custody the rest of his life. So that's just what it is. That's just what it is. So let's see. Question: when two people talk over each other, how does the court reporter capture everything that's said? The court reporter probably has a recording where they can go back and fill in because he talks over all the time. So there are a lot of devices that the court reporters use. I have the stenography machines that can record. So they probably have that going so that they can go back and fix it. So that's what that is. Let's see. We've got some other questions that came in right at the end that I want to make sure we get to. And I'm trying to get to questions, not just questions and super chats. What difference does any of this make? Don asked. Yes. Well, they are very, very much trying to protect the record in this case after this conviction because it's going to go up on appeal. It is in this kind of conviction going to get appealed, whether there's grounds that would overturn it or not, whether there's grounds that are harmless error or not. So it will get appealed. So they are making an extra record for appeal. So when is Emily going to be a judge? Never. Nope. I'll judge things on the internet. I will preside over court of public opinion. We haven't even done our court of public opinion. I'll do it on social about candy corn. Bet. We could actually do that now. Miguelina, can we put up another poll about candy corn? We're going to keep polling it until everybody gets it right. Not the way I do a poll. Candy corn, delicious or disgusting? That is the poll. So no, Emily doesn't want to be a judge. Truly, Emily doesn't want to be a judge. I want to be a legal commentator. I've spent plenty of time in the courtroom. I would be a terrible judge because I cannot control my face. I would get very angry with parties. I interrupt all the time, which is so rude. ADHD, sometimes I cannot help myself. So interrupting would be awful. So I am so good at being here. Also, this is so much more fun for me because I love y'all. I can't sit in a trial and not run commentary. And I can't sit as a judge and run commentary over defense attorneys and being like, that's really what we're going with? That's the opening statement we're giving right now? Okay. I can't. So I can't run commentary literally on everything. I'm terrible to watch a movie with. And even when I go to concerts with my friends, there's times I'm like, this crowd seems a little off tonight. Like, what do we think? Like, what's going on there with these two? Do you think it's a first date? Do you think they're married? Do you think they broke up and got together? Do you think somebody bought the tickets and then they ended up going together? Like, what's the situation? I can't stop. Terrible. Question, do you think he would be like this if he had a lawyer? Yeah. And I think his lawyers weren't listening to him and trying to tailor this down, which is why he wanted to represent himself. But his lawyers would get the benefit of all of this, not him. Natalie Lawyer Chick is a defense attorney. She's also does a lot of coverage on sovereign citizens. Would be a great place to look for more commentary on what representing sovereign citizens is like. I have only worked on the other side of the bench or the courtroom. Why do we not get to see them taking him in and out? Security protocol. They don't want to show the protocols they use. Emily, can she now hold him in contempt? Mike, sorry, not Mark. I have a friend named Mark. Mike McGuire. She could, but he's not really there. And he hasn't really gotten to the point where he needs to be held in contempt. He just needs to be muted because he's not adhering to the rules of the court and decorum, but it's not really contemptuous. And there's no point in holding him in contempt. There's no real point in holding him in contempt after the fact. He's going to be in custody. What are they going to do? Hold him in custody more? It's like, put me in custody more. He's in custody. What else are they going to do? Fine him? He's not going to pay it. So what do you do to him? There's nothing else to be done. Question, is an appeal a sure thing? Yes. Seems a shame to not have complete closure for the people affected. I think, well, in all murder convictions, there's an appeal. I don't think it's automatic in Wisconsin. I need to ask, or actually just go read the statute, but he will get appellate counsel. It will be appealed. It's unlikely to go anywhere, but in these kinds of cases, it is practically pro forma that there will be an appeal. And that's how the system works. Have another court review it. I don't think there's anything that's going to be a problem. Shayla Gilmore, today is my birthday. I'm choosing to spend it with you. Thank you. Happy birthday. Cheers. Happy Halloween birthday to you. Even though it's a Monday Halloween birthday, which is always, kind of a bummer. Are all in custody defendants shackled or just those they are concerned about? So this can vary by jurisdiction. So all is not really what I'm saying. It is common that when defendants that are in custody come into court, they are shackled at the wrist and at the feet. And then they come in and sit down and they're not unshackled. In trial, they are unshackled. Some will just be shackled by their feet so they can't run away. I had a defendant run out of court. It was quite a day because they were unshackled and they just ran right out of court and kept on running. I don't think they knew that the court I was at was also a juvenile court, was in the middle of a golf course. So once they got out the doors, there was nowhere to go because you are at the very back of a very large golf course. And they, the sheriffs run fast. So, but yes, you want to prevent people from trying to run out of the courthouse, cause problems, grab people, harm people in the audience. There's lots of reasons why you would, there's lots of reasons why you have people shackled, but when they have an attorney, they don't have to stand up and present evidence. So they can be just shackled with their feet shackled together, as opposed to being shackled to a table. He needed to be able to get up and move around without hearing them. The shackles he was in today, you saw him pulling his arms up. He was shackled through his wrists, through a waist, and then the feet. You can hear those. They make quite a lot of noise. And that's part of the thing too. You don't want that noise to persuade the jury either. Best line ever, the sheriffs run fast. They do. You know what was funny is 2 of the DAs went running. Did I even get my ass out of the chair? Not a fucking chance. Was I like, what I'm going to do right now is chase this juvenile out of the courthouse? No. Like that thought never crossed my mind. 2 of the other DAs went tearing off out of the courtroom. Do we need to tell this story? Well, maybe we'll tell this story. We've got a few more Q&As and then we'll tell the story about the juvenile running out of juvenile court. It was just a day. But I don't run. I should. I mean, I should run. I don't run. And was this before? This was after my ACL tear. Yeah, I don't run. I was a water sport girl. I grew up swimming and playing water polo and at the beach. And there were times that our like college water polo team would make us run. I'm like, I am going to trip over a crack that no one can see and break a wrist. Like I am not good on my feet at all. Not good. Not good. And the coach would be like, we're running. And then we had to do those awful fucking sprints where you're running in a line and the person from the back has to sprint to the front and then you just keep going. The upperclassmen at the front would pick up the pace when you're trying to sprint to get at the front of the line. I hated literally nothing more than that. I'm like, these boobs don't want to run. These legs don't want to run. Like, Too many folks saying gag and tape his mouth. It's not humane treatment. We don't do that. I mean, there are limited circumstances where someone can be gagged in court, but when tech makes it available to not do that, I think most judges would rather not do that. Truly. It's not supposed to be additional punishment. It's supposed to make sure that the court can stay safe. Also, he's not spitting. Like, he's not doing the things that would cause someone to have like a face mask. Thank you, Laura, for sharing. Let's see. I don't think he grasped the protection for him. He doesn't. Thank you for covering this mentally exhausted case. I didn't cover the whole thing for a reason. So I'm glad we're here. Mitz said went live right when I went on lunch break. Hopefully that's a good thing. Found you during Depp Heard case. Love you. Thank you so much, Christy. I know nothing about the law, so sorry if this is basic. We're here to answer basic questions. All questions are welcome. Will this judge decide his sentence? Yes. Yes, this judge is the sentencing judge. It is. Did you hear yourself on the YouTube Technoblade tribute? I think I didn't. Oh, I will go look. I didn't. I had a hard time talking about Technoblade passing. It was just very, very, very sad. So, and you all know we've broken down all of the walls to emotion, and now we kept them welled up right under the surface. It's a good thing. Sputnik. I forget that we need to explain candy corn because the rest of the world has common sense and they're like, this candy makes no sense. This candy makes no sense. Candy corn is a delightful little, I don't even have a bag in here. They're in the other thing. They clipped your Technoblade Never Dies. I'm so glad they did. I'll have to show my kids. My kids will be thrilled. Chat, explain candy corn. They're a little candy. They are highly divisive. Some people love them. Some people hate them. There's not a lot of in between. The in between tends to be like, I wouldn't put that in my mouth. It's just, I love everything about them. So, but a lot of countries are just like, what we're not going to do is that. People are like, it tastes like wax. I love them. I love them. I love them. I also love the little pumpkins. So this is why there's a poll, because it's very divisive. So yes. So candy corn is like Marmite. Then yes, in the fact that either love it or hate it, no in between. Love it or hate it, no in between. And then they just have tried to make other flavors of it. OG is best. My family hates them. I love them. I love the little pumpkins too. Future prison law library clerk in the making. I mean, he definitely will be probably giving legal advice. He will be a jailhouse lawyer. Daniela asked the important question, do the families get to speak? Those who choose to. And I think what we heard the DA say is there were like 65 people that wanted to speak in court, others that wanted to have statements read. I will tell you from my own experience, reading impact statements was one of the hardest things I have ever done in court. It is gut-wrenching to read a first-person account of truly raw and unfiltered pain. It is very, very difficult. So some wanted to have them read and some just wanted to submit letters to the court so the court could read them. So there would be, did they say 36 and more? I might have inverted the numbers. That's very possible. So those statements will happen on the 15th. The judge will sentence on the 16th in the afternoon. So yes. Ray asked, what is cases resolving? So the court had mentioned on the 15th, they have 8 different jury trials set. Some of those cases will not go to trial. They will resolve, meaning they will either be dismissed or there will be a guilty plea, but the case will settle not going to trial. So it will resolve in some way and be over. So cases resolving is very much the common vernacular to say that we have 8 trials set and maybe 2 of them will go to trial. Maybe none of them will go to trial. So it's very much the case has a resolution. So I will go back and look again. I wrote that Darrell Brooks wanted 20 people to speak. I didn't write what the DA said. So I remember going, oh, wow, that's a lot. But I could have absolutely got my numbers mixed up. It happens. I'll go back and watch it before I share it. Are the jury done or do they have to stay until sentencing? The jury was dismissed when they came back with a verdict and they are done. They are absolutely done. Their role has been fulfilled and they are done. So the sentencing falls with the judge. Booze Baby 103 said, just watch your TED Talk, Moving Life Altering. Thank you. I unwittingly gave a part 2, I think, of my TED Talk in our members only live, our second members only live of October. We had a whole conversation about it. Caitlin said I tore my ACL 4 times. Oh, I'm so sorry. ACL recovery blows. It sure does. It sure does. There was a video game I was very into when I was recovering from my ACL surgery. First, I watched all of Doctor Who. All of Doctor Who during my ACL recovery. I watched it again during back surgery recovery. But there was a zombie video game in a mall that I loved and I played all the time. Dead Rising? I think it was Dead Rising. Couldn't stop. So couldn't get off the couch. Sat there with my leg up waiting for my husband to come home. Like I had like a snack like cooler next to me. And the only thing I would get up for really is to go to the bathroom. Yes, Dead Rising. It was great. So that's what I did during my ACL recovery, but it did suck. It also pushed back my career trajectory a little bit, which I wasn't thrilled with because I tore my ACL at kickboxing very early on in my DA career because the floor at the gym didn't have a pad under the bag and was wet. So I will absolutely go look at the Technoblade tribute. I'm just happy to be included. So let's see. First super chat to tell you I dressed up as you for Halloween today. If there's pictures, can you tag me? I would love to see them. And thank you, Brianna. Yay. Thank you, EDB mods. Love this community. Thank you so much. I love. Thank you. Yeah, I think Brooks was upset he didn't have a box for it. I'm going to answer the questions. Now that the trial is over, can't they gag him instead of banishing him? I think it's easier to banish him. I think I went into that pretty heavily earlier. Are all in custody defendants shackled? I know I answered that. She says she's going to have an officer testify. I don't know. You could testify after the verdict. Is this normal? Yes, it's normal in the fact that they needed to make a record. So they needed to make a record. So that's why they testified. It wasn't testifying for guilt. It was testifying for the record. We're at the, yeah, he was done. Brooks was done today. I don't know if Erica will choose to speak or not. She testified twice. I just don't know. Will he still be tried on his other cases? Ladybug, I have not looked up what his other cases are. I will. But he has the choice. He has the choice. He can choose to just take a deal. He could take a plea deal, plead guilty to the charges, and have his sentence run. I'm sure they would let him run concurrent to whatever, but it doesn't matter because he's going to get so many life sentences, concurrent or consecutive. He's never going to serve all the time that he's going to be sentenced to on this case ever. He's just, it's going to be longer than his lifespan. So he could just say, fine, whatever. Just, I plea, tack the time on. Do I think that's in line with his personality? No. I think he very much likes being in the courtroom and that he might just try to fire his attorneys and go to trial and just because he has the ability to not be in custody every day. It's something else to do to be in trial. And I could see him going that direction just because it's something else to do or because he thinks he might get a win on those. I don't know. I think he could. I'm living for the sass of ask your lawyer. Well, if he had a lawyer, all of these things would be much easier for him. Thank you. You're welcome, Graham. Katie said it's a Wisconsin accent thing. Shock and soft both have the same vowel sound. It's possible, very possible. What does the type of restraint matter? He brought it up. I know we covered that earlier. We're getting to some of the older super chats. Allie said, can people stop making fun of Brooks's accent and his use of AAVE? There are plenty of things to criticize him for. His accent mispronunciations and use of AAVE aren't among those things. Thanks, Allie. I know this came in before I addressed it, so I appreciate that. I think hopefully the chat is all on the same page. I think he's confusing taser and shackles for a shock device. I don't even know if anybody would have brought up taser. Emily said, for the record, thick hair gets frizzy. Yeah, but you still get thick hair though. Know someone on the jury, they got trauma support. Good. I hope that they do. And again, this varies by jurisdiction. And if they do, that would be provided by, not provided by the state, but accommodated for by the state. So they would have professionals that could accommodate for it. Should we end our poll? We should end our poll for candy corn. Candy corn is a wonderful blend of creamy fondant, rich marshmallow, and warm vanilla notes. It's sugar in a corn, and it's delicious. So good. Question, would love to see a reaction to your mention in Nate's Boozy lawsuit. What? Wait, what? Wait, what? Emily, I just need to start keeping a list of the lawsuits I've been mentioned in. I have not seen it. So maybe we'll look at Nate's Boozy lawsuit tomorrow during Coffee and Cursey Words, which means I won't read it. I'll do a first look tomorrow. We'll do a first look tomorrow. How about that? Chat, what do you think? Do we just do a first look at the Boozy suit tomorrow? He already blocked me. I was at band all weekend. And then, okay, to be totally fair, I was not just at band all weekend. I wasn't on my phone much while I was at band. I wasn't on the phone much while I'm at band. I love being able to just be where I'm at. But also I was in Atlanta for the night before I came back to Tennessee, and I got to go to IKEA. There isn't an IKEA close to me, so I got to go to IKEA. So I spent part of the day yesterday at IKEA and then part of the day driving back to Tennessee in the rain. But it was so funny because my husband called. He's like, how's the weather in Georgia? I'm like, actually, the weather in Georgia as we're like driving through was like Seattle mist. So it wasn't like raining, but it wasn't not raining. It was just, the air was super wet. It was just misty. The second we got through, because on the way home, there is, you're in Georgia, then you're in Tennessee, then you're back in Georgia, then you're back in Tennessee. So you're like, so as I get to the second welcome to Tennessee sign on the drive home from Atlanta, I see, Tennessee welcomes you, and then torrential rain, just torrential rain. So I called my husband back. I was like, well, we entered Tennessee and the weather was just torrential rain. People are like, why are you mentioned in the case? I don't know. We're going to find out tomorrow. Chat, don't spoil it for me. Seattle mist. I totally feel that. There's no other way to explain it. I went to law school at Seattle U, my first year of law school. I loved living in Seattle. I don't know what to say other than it was Seattle mist. So I live near the IKEA in Atlanta. I had a great time. Not only did I get to go to IKEA, which I love IKEA, but I also went to the Avenues in Buckhead. It was so cool. No, was it Buckhead Village? It might have been Buckhead Village, where the Hermes is. And it was just gorgeous. I wanted to go pick up a perfume. It was so good. Was it the Village? It might have been Buckhead Village. It was lovely. It was just lovely. I really enjoy Atlanta. So it was nice to be there just for a little bit. So let's see. It's called Seattle Spittle. That's fair. So it was fun. All right. IKEA is honestly a strange theme park. No rides at all. True. Emily's absolutely blocked by Boozy. I was blocked by Boozy. I never even said anything about Boozy and I got blocked. All right. 6,000 votes. So that chat, thank you for not spoilers. I will read the lawsuit tomorrow. We'll just do a first look tomorrow. We need something less heavy, and defamation is always a little less heavy. Candy corn, disgusting, 50% delicious, 49%, 6,000 votes. I see some of you abstained. So it's fair. Who is Boozy? Oh, we'll get there tomorrow. Don't you worry. So somebody said, I've never been to IKEA. Why do people love it so much? Chat, I will let you explain. I have my own reasons for loving IKEA, but I've used IKEA since college. It's just so easy. So rain over Mount Eagle is terrible. There was quite a lot of rain. So then it became a much more careful drive for me through the passes and stuff. Nate's lawsuit gets spicy. Oh, goody. It's an amazingly sassy lawsuit. I don't expect anything less from Ron Coleman. So that's what we're doing in tomorrow. So what'd you get at IKEA? Oh, I needed new bins, but I also got like a laundry octopus. And my family was like, what is this? I'm like, it's a laundry octopus. And they're like, what? I'm like, don't you worry. I'll share what I got on Instagram. I've been in the middle of reworking my freezer so that Emily, is this going to sound terrible? Yeah, whatever. I'm in the middle of reworking my freezer because I saw a TikTok about ice. I'll have to share the TikTok to make it make sense. But I saw a TikTok about ice, and my little ADHD brain went, ooh, oh, we need to do that. So with starting to organize my my freezer for my whiskey ice cubes, I also needed to reorganize the rest of my freezer. So I organized the outside freezer and the inside freezer. So now it became a thing. But then I wanted the IKEA bins that we had because we lived fairly close to IKEA in Southern California and could just run to IKEA to grab stuff. And then we didn't. So I needed the bins. So I will share all of that for sure. Just someone is like, Juvie story already? No. Nope. We haven't even started yet. Y'all love the laundry octopus, right? So I'm very excited. So I also picked up some cookies, some candies. Not the ice TikTok. Yes, the ice TikTok. I'm obsessed with ice cocktail art right now. The stamps are right. There's so much to be done. I love whiskey. So, it is what it is. All right. I'm going to do a few more question and answers. I know there's more. There's more super chats that I'm going to go through and acknowledge them. And I appreciate it. So thank you, Allison. I appreciate you. We went from stacks of hearsay to stacks of trials. I made a TikTok about the other stacks. Look, Emily's a little sassier over on the ticky talk talks. I've decided I just don't care. And I will always do case updates, but sometimes we're going to do sassy lawyer reacts. So that's over there too. Somebody on TikTok, I'll get it occasionally on these streams too. Somebody on TikTok, as I was TikTok duetting a TikTok about stacks, they were like, why do you keep talking? I'm like, I'm duetting another TikTok. You could just click on the thing and go watch the other TikTok. This is what I do. Why are you talking? That's what I do. That's the answer. Why are you talking? Because that's what I do. Are all his people just sovereign citizen supporters? I think he will be. I think Brooks will be disappointed when he sees how many people actually come to court. Could he be able to get a public defender still to help him do this part? Not that he'd actually do it. I don't think the court would appoint him a lawyer for sentencing, given that the sentencing is pretty statutorily set. There's not a ton that he can do to help himself. And I think if this was a different type of case, maybe he could have gotten a penalty phase attorney, but I don't think that's even possible. And he hasn't asked for it. He said that he had shocks on in trial and she never denied that he had them on the whole time. Why would they seal it? I'm not on his side, but I don't get it. Rachel M., you never have to feel bad about playing devil's advocate. We can always have conversations about why this, why that. They sealed the types of restraints he had from public so people can't know exactly pictures of what restraints they're using so that others can't plan really truly for escape from court. She never denied it, probably because she didn't want to fight with him over it, truly. And that's why she made a record at the end, I would imagine. So it would have just taken up more time. That's my guess. Could he argue that his rights were denied since the suicide protocol didn't allow him to contact people to give a statement? Not in a way that would come up on appeal. And he should be off of protocol after this court appearance so that he can do those things. But no, being on protocol and not being able to access things is not going to cause a problem. I think new case law will be created thanks to Wisconsin versus Brooks. It depends on it. It depends on what goes up on appeal. So when we see an appeal, we can go over it. So we can see. Can't a prospective jurors state that they have issues looking at gory pictures before getting on a jury? They're not really asked about that, depending on the case. So they're not really asked. Any must-see places for a day in Nashville? James, it depends. Must-see, I think the Parthenon is must-see. If you're really into country music, the Country Music Hall of Fame is great. I like the on-off bus tours through the trolley tours. I think they're great. You get to see a whole lot of Nashville. And it depends on what you want to do. I also very much like the alcohol-serving Taco Bell down on Broadway. Do you think she already knows what the sentence is? I think the judge knows what the statutory sentence is. I don't think there's a lot of discretion for the court. But no, the judge is going to listen to all the statements too. But I think the judge has an idea of what the statutory sentence is and might need to add it up again or have the DAs add it up again. Maybe sovereign citizens don't pose prompt risk yet. Their view of an example of the laws are public risk. You think there should be ample for section psyche. I don't think him not wanting to adhere to the laws of the land, I don't think qualifies him for psychiatric help. Legally speaking, I don't. He doesn't want to adhere to the laws of the land. So he's like, I don't believe that. But I don't think that would automatically put him into mental health. There's a lot of considerations in court before people go into mental health, forced mental health. And that doesn't, like, I disagree with the Constitution, or I disagree with how the Constitution is being applied, or I don't recognize states' rights isn't going to be it. And I don't think sovereign citizens pose much of a danger. It is, I don't even know. More along the lines of a conspiracy theory of, look, these rules don't even apply. They do though. And those tactics never work in court. It just delays things. But a lot of things people do delay things in court. When you're taking people's liberty, dealing with a little delay in that process is kind of part of it. I understand that he has family, but certain charges should limit people that can speak for him. His goal is to further trauma for the victims. I don't know if his goal is further trauma for the victims, but he has constitutional rights protected, and none of the victims' rights statutes even address limiting the defendant's ability to speak on his own behalf for sentencing, because he's the one whose liberty is taken away. And I understand that the considerations are for the defendant after the victims, in this case, have had their lives taken away, with no rights, no protocol, no constitution, no protections. I completely understand. And it is a frustrating balance that our criminal justice system strikes, because the victims had no say, not even a say, no protection from what was done. And it's a hard thing, but he has the right to speak at sentencing because the government is taking away his liberty. He's the one that took everything away from the victims. But when the government is the one taking things away, then the Constitution applies and protects. And even when it's difficult, even when you're just like, throw him under the jail. I don't want to hear anything. I don't want to hear it. Just sentence him. It is those cases where I personal opinions, believe it is most important to adhere to the rights that the Constitution grants, because it's much easier to let those slip when it's something or someone or some action that you just hate. But that builds in the ability for people whose rights are most needed, for those who are wrongly accused, wrongly convicted, for all the protections that the Constitution needs to give. We have to uphold to the letter of the law, the Constitution, for those that are most abhorrent. So that's the point, and that's the hard part. And I think truly, as a civilized society, it's the least truly that we can do is be able to say, I want this to be done right. I want justice to be done right. And if he spends the rest of his life in prison, then that's what happens. And I want it to be done properly, so that this doesn't come back on appeal, so that this doesn't have to happen again, so that another jury doesn't have to see those pictures and that video that the DAs played at the end. So other DAs don't have to do this case again. So Brooks doesn't have his 10 minutes on television again. I want it to be done right, so it's done. I love when he says, I didn't interrupt you. I feel like he's saying, do you want to miss a biscuit, Mr. Brooks? He's saying, see, Your Honor, see, I'm playing this little game that we're doing. Now give me what I want, is how it feels to me. Brooks Law and Order Dictionary, he definitely did have his own dictionary of what he believed. Can the judge order Brooks restrained and forced to listen to victim impact statements? I would have to look at case law. I don't think it would be helpful at all. He has the right to be there. I think he can be in the other courtroom. He definitely won't be allowed to interrupt. I will just warn you all now, victim impact statements are very emotional, can be very hard, and some will direct it at him vehemently. So I think he'll be in the other courtroom. So, I thought there was a pretrial hearing about using shocks. I don't know if there was or if there wasn't. We could go back and look. Caitlin, thank you for the words of encouragement to a fellow law nerd just celebrated 9 years of recovery. You can do this. Take it one breath at a time. We are all cheering for you. That's exactly right. This is a fantastic community. Thank you all for sharing so vulnerably and so honestly your own successes. It's incredible to see. He killed 6 people, drove down a parade route in my hometown. Can we stop acting like shocking him would be the end of the world with Rob on this one? Piper, again, there's protocols for this, and I didn't say it was the end of the world, but I also think at this point, he has not acted in a way where court protocol allows for it. And I rather have him punished again the right way, like I just said, than in a way that's going to bring this back up for appeal, truly. So that's why. That's why. By the way, there was an arrest in the Delphi murders. I have not seen anything this morning, so I will go look. Let's see. You are never allowed to watch me in trial. Just kidding. Anytime you want, although Judge A wouldn't appreciate the commentary that you'd likely get yeeted. I wouldn't go into court. I can't be in court because I talk. It needs to be streaming. EDB says we're not allowed to run around and shock people. Got TikTok. Run around shocking people got TikTok vibes. My brain is not connecting the two. I'm sorry. Question. Your juvenile court was in the middle of a golf course. We'll have a conversation. Tomorrow we're going to live react. Can we talk about the murder, the developments? I will take a look. I'm going to react to that tomorrow. Let's see. Candy corn with peanuts is super yummy. Candy corn with anything is super yummy. My son is 35, a deputy, and runs a 4:40 fast. Yeah, they are fast. They are very fast. So ACL right knee, off crutches 3 weeks, complete meniscus tear left knee. Ouch, ouch, ouch. I'm sorry, Enchanted Wolf. That's a long recovery. That's not good. My mom makes candy corn with salted peanuts for a salty sweet treat. I found that yucky, but she loved it. Now I'd give anything to buy her a bag. Oh, I'm sorry for your loss, Janice. And those are the things, those are the little quirks we remember. November 15th, we will be going through a box of Kleenex and Ugly Cry all day. Yep. We're going to ugly cry together, though, and I'm not going to apologize for it. We're just going to do it. We're just going to do it. Let's talk about people running out of court. Let's just have a conversation about that. When will we get in depth on the murders? I've been covering them. I've been touching in. I think the Murdaugh Murders podcast with Mandy Matney is fantastic. They cover one case and they have been amazing. When that starts trial, we will be doing all Murdaugh all the time. But I have to be honest, when I cover Murdaugh here on YouTube, truly not as many of you watch it. Not as many of you watch it. Just facts. So I will absolutely be covering it and circling back. We've got a couple other cases we've got to circle back to. January says, I was at BOA in Jacksonville Saturday watching the bands compete. Weren't they so good? Weren't they so good? The Jacksonville State Band, first of all, and then we're going to talk about juveniles. First of all, Jacksonville State University, they are the Gamecocks. So their school has shirts that just say cocky on them, which I thought was hilarious. I love cheeky university merch. It was so good. Their band was so good. They were so good. I loved seeing all the high school bands compete. They were so different and they were so fun. But I also loved getting to see the college band perform. They were great. And my watch gave me like 3 decibel warnings while we were watching the band compete. My watch was like, girl, what are you doing? They were so loud, they set off my decibel warnings. It was absolutely incredible. Their band was so fucking good. They were so fucking good. And it was just so much fun to see. I love it. Bethany said, former marching Southerner hero. I'm so excited to know you love them. They were amazing. They were great. Their show was great. Their theming was great. It's just a fantastic show. And I absolutely loved it. I loved every single minute of it. I sat there like just ear to ear band geek grinning. I loved seeing all the other band kids sitting in the stands, just being so inspired by watching an amazing college band. I just loved it. So it was so much fun. And it was really fun watching the band and the high school bands all interact at the end of the band's performance, and just how much camaraderie and like fellowship there was. And then there were kids in the band just messing around and doing like backflips. And eventually they did the lift from Dirty Dancing, and the high school kids are going nuts. And it was just so good. It was just so good. It was just so good. I loved every single minute of it. My jaw drops every time I watch a DCI band. My friends did DCI. Look, I did marching band and loved it, and then also did water polo. When it was clear that water polo was the course that I was going to follow, stopping doing band was so hard. So not being able to do DCI when my friends went and did all that, I was like, oh, but I loved water polo, and it was very hard to choose both. So I love how many band kids and band parents are in the chat. It's great. It's great. YouTube is chock full of great Southern and the HBCU bands are unlike anything else. And they are a lot of fun. My sophomore year, we made BOA finals, and going out on the field at the end was amazing. It is amazing. There were some great bands. Okay. What was I talking? I was talking about something. Are you surprised he didn't ask to not be present during sentencing? No, I think he wants to have his say. And I think he's going to make a statement. I don't know how that's going to go, but I think he's going to make a statement. Can the judge cut off statements, or do they get an allotted time? I don't think the judge will cut off statements. The judge is allotted a full day and a half for sentencing. And from my personal experience, I have found that people struggle to get through their statements and tend to keep them a little shorter because it is so very, very difficult. So we'll see. We will see. Henhouse Beth, thank you for the reminder. We were going to talk about court running. That's what we were going to talk about. You guys, please keep talking about band in the chat. I know the mods are like, we're in Q&A, so we're kind of like open argument, free form at this point. So I worked at a juvenile court that also was in a golf course. Now, I still don't know how this happened, but I would drive through the entire golf course to get to my courthouse. The courthouse also had a housing unit, which is a story for another day. So there is a real possibility that those who are brought to this housing unit and court could come in at night and not necessarily know that the courthouse and the housing unit attached to the court were actually in the middle of a golf course. I don't know how any of this happened. I never once played golf while I was working there. We did go sometimes eat lunch at the golf course little food place because they had basically bar food. It was not like Top Golf food. I mean, but I guess Top Golf food is bar food. French fries, burgers, grilled cheese, shit like that. So occasionally we would go eat at the golf course. I still don't know how this juvenile facility for the county ended up. Maybe it's a county-owned golf course. I don't know. Now I'm going to have to look it up. I'll do a deep dive at some point. So we've got this golf course that I had to drive through to get to work. And then the juvenile facility with multiple courtrooms, and then a juvenile detention facility on site. So the parking lot was always filled with, us and the probation office and everything else. So this particular day, I don't even remember what the case was, but it was my case. I'm sitting there, and there's like, the juvenile courts are closed courts. So they're very much smaller. They don't have jury boxes or anything like that. So our juvenile courts were set up, it almost looked like a hospital because they had like lines. So there was a massive waiting area in front, and then like a red line, a blue line, and a yellow line. And so those coordinated to the different courtrooms, and it would be like, family, Jones family, follow the red line to Department 2, whatever. And so there would be a line of juveniles and generally parents that were out of custody outside. The in custodies would come in through a different door, and the parents could come in when their case was up. And it would just be the kid whose case it is, and a family member, a representative from the probation department was always in court, the defense attorney, the DA, the court staff, and that was it. There were also sometimes other DAs if they need to have a case that's coming up. There would sometimes be other DAs in the courtroom. This particular day, 2 of my colleagues were in the courtroom. Myself, the defense attorney, the defendant, the deputy who's a sheriff, and the rest of the court staff. I don't know what we were doing, but most of the juveniles did not come into court shackled. They just didn't need to be. And the juvenile housing facility wasn't like that for the most part. It was more like a locked camp where they had bunks and they had more outside time. There's definitely more acknowledgement that, again, they are minors and they didn't always come into the courtroom shackled. They weren't wearing like jail jumpsuits. They were normally wearing sweatpants, things like that. So this juvenile's sitting in there and we're going through whatever sentencing we were going through because it was the end of the case. And I was looking at the court, not looking at the juvenile. I rarely looked because you're sitting on one table. So it's like down the road. So I'm not looking down the aisle. I'm looking at the judge. That's what the bailiff is for, by the way, to watch the minor. They apparently weren't. So the minor had, I think, been wiggling their chair out and backing up and backing up and backing up. And at one point, just ran. And I was like, the fuck? Like literally up and just ran through the door. The door is unlocked, the door that goes out. So there's a custody door, like where the judge was, a custody door that came out, and then the door to the out. So it's not a very big courthouse. So once you get out, it's just one floor, no elevators. So the kid just goes running out. And I'm just like, the deputy gets up, because the deputy wasn't standing. The deputy was sitting behind their chair. Just everyone who has ever worked in courts, just cringe all you want. So the deputy gets up and goes to run after the minor and trips on his desk leg and breaks his arm. Just breaks his arm. Just trips and breaks his arm. At that point, to the best of my memory, he is radioing for other people. And the two DAs that were in the courtroom, the second this kid's out the door, they go running. They got in a whole bunch of trouble for this later. So, well, I don't know how much trouble they got in up the chain. They got in trouble with our immediate supervisor. They go running. So, but by that point, other deputies, you can hear them running. So you can hear the running. And I'm still sitting there like, what in the fuck just happened? Me, what? Running. So at this point, I don't want to get in trouble. Like, I don't want to get in the way. Like, there are deputies now running out of court. So I don't want to like go watch, but also I want to go watch. So I give it a minute and then go out to kind of the front of the courthouse. And the people in the waiting room are like, because nobody tells them what happens. There's a kid in sweatpants running, and then DAs running, and then sheriff's deputies running. I think somebody got a golf cart. They caught up with the kid, not the DAs in their suits and work shoes. The deputies caught up with the kid and brought him back in. And then he got charged with all of the other things. He did not get charged, to the best of my memory, because we had a long discussion about whether he was going to get charged with evading causing injury. And it was my belief that the causing injury was on the deputy. The minor did not cause the deputy to trip. Like, he wasn't trying to like throw things in the deputy's way. And I believe that that charge was meant for someone who tried to cause injury during the evading to the deputies, not that the deputy tripped over his own desk and hurt himself. So we ended up not charging it with the essentially evading or escaping causing injury, but he ended up getting additional charges and just mess. It was a mess. And that deputy was out forever with the broken arm, just out forever. But again, when somebody goes running, my first instinct is not to run after them. Just not. The other two deputies, the deputy DAs. So then we get back into the office and my supervisor is like, what the fuck did you think you were going to do? You do not have the authority to tackle. Like, what are you going to do? What are you going to do? Are you going to tackle him? You're just in the deputy's way. What if you get tased as the deputies are trying to get this minor? What if this minor attacks you? Then what? What are you going to do? DAs, you have no weapons. You are not authorized to put hands on literally fucking anyone. What did you think you were going to do? One of the DAs was like, I mean, lizard brain, I guess. You just chase. And I was like, what? You just chase. It's like somebody runs, we just chase. I don't know. Both of them were like, we didn't even think, we just ran. Didn't even think, just ran. But my boss was like, these are all the things that could go wrong. All of the things that could go wrong. Like, if the deputies, you're in their way at this point. DAs, get the fuck out of their way and let them do their job. We're in the middle of a golf course. Where is he going to go? Seriously. Where is he going to go? And they were just like, run. I was like, not my first. That says a lot about me. My first instinct was to sit, stay, don't get in the way. Like literally don't get in the way. Don't get in the way was my first instinct. Anyway, it was, they definitely got yelled at by my supervisor, who was like, the county doesn't need to get sued because 2 DAs caused problems, or you don't need to get hurt, or you don't need to hurt that. Like, you can't go hands-on with people. Your DAs, what the fuck? What the fuck? It was hilarious. One of those 2 DAs, fun fact, is now an FBI agent. I guess he was like, ooh, run chase. Better. I want to do that. That's better. That's better than lawyering. I want to go be an FBI agent where I can run chase. So that's what he did. Caro said, my first instinct, don't run for anything but survival. Right. I wasn't being chased. I'm not chasing. Don't worry. I'm not chasing you. Emily's instinct, let better prepared people handle it. Yep. What am I going to do? What am I going to do in my court clothes? Nope. Nope. Definitely not. Definitely not. The DAs are those people who run towards trouble sometimes. I mean, I am not one who stays out of it either. I have definitely like gotten out of a car during not me. There was a very large car wreck as we were heading to the Container Store. Do you see a theme? I like home organization, but my family and I were heading to the Container Store, and there was a very large car wreck that we saw and narrowly avoided. And I parked the car, got out of the car, and was like stopping traffic myself just in the road because it was such a whole thing. Like I will take charge of a situation that I have no business taking charge of sometimes. But I was like, I can do this because it was a very serious car accident. I'm like, this is a mess and we have to wait until law enforcement gets here. I also knew that we were in the middle of jurisdictions. And so in my brain, I'm like, we're in the middle, we're in between, we're on the border of El Segundo and LAPD. And if we have to get LAPD here, this is going to take a minute and this is a mess. This is a crazy story. It was a crazy accident. And I saw the whole thing go down. Somebody was trying to make a U-turn across 4 lanes of traffic and got T-boned by a Lexus. They shouldn't have been doing the thing they were doing. And they were in a small convertible. So I could see the injuries that had happened. This was also while I was a DA, and I worked a lot of vehiculars. Like my brain was I worked a lot of vehiculars. So I also knew, because we were right by the beach, I also called the lifeguards and was like, can somebody just bring flares? And they're like, this isn't really our jurisdiction. I'm like, just a few flares. They're like, and I'm like, I realize that your jurisdiction ends with the road, but so I stayed because the car that T-boned the car was not in the wrong. And I was like, I'll be damned. Like I was very certain at this moment that one of the passengers, if not multiple of the passengers in the convertible, were not going to survive. That's where I was at. So I was like, this is not the fault. The car that hit them, this is not their fault at all. So as I'm stopping my car, by the way, now we're into another story and then we'll finish story time. But as I'm pulling over, because I barely missed this accident the T-boning when it happened, the driver from the Lexus that T-boned the other car gets up and starts running towards the other car. My DA brain is like, oh shit, this person's going to go attack the person in the other car. That's where my brain went. They're going to go attack the person in the other car for pulling out in front of them and causing this accident. And I could see their doors were open. There's a female front passenger and a kid in a car seat in this Lexus that is now smashed in at the front. And there are 5 apparent very injured people in this convertible. So I'm now worried that the person who hit the convertible is going to go attack the driver, because I'm like, why wouldn't you be pissed? Why wouldn't you be like, they pulled right in front of this car in a way that there's no way they could see it because of the way that there was another car going by. And I was like, this is bad. So I get out and start running. That is because I'm now worried there's going to be more. And I'm like trying to call the police on my phone and stop other cars. What the fuck did I think I was doing? I don't know. This is where I react. And the dude is starting to try to talk to the driver. And I'm like, sir, what are you doing? He's like, I'm a doctor. And I'm like, what? And he's like, I'm a doctor. I'm a spine surgeon. I'm a doctor. And I'm like, what? And he's like, I just want to make sure everyone's okay. And I'm like, what? Wait, what? Is everyone in your car okay? He didn't check on what I now know are his wife and kid in his car and runs over because the injury looks so bad. My DA brain is like, he is going to literally put hands on these people because anger. And his thought was, I've got to see if they're okay. And I was just so, what? You've short-circuited my brain because this is not how people work. You have short-circuited my brain. And so he starts checking on them. I am calling the police, and I am calling not just the police 911. I am calling personal cell phone numbers of people I work with at the local PD. And I'm like, I'm going to need someone to come down here. And they're like, well, that's right on the cusp of our and I'm like, I don't give a fuck. We are blocking all of the traffic. This is the only way through the South Bay on Vista Del Mar. This is the only way through. So what I'm going to need someone to do is fucking help, because I'm standing in the middle of the road and these people are bleeding out of ears and noses. And there are people in cars. There are kids. It's a thing. So I go over and check on the other car. I go back to my car, and then other people stopped and helped me with traffic. Funny enough, a friend of mine was trying to get to a wedding through the traffic. I was like, is that your car? And I'm like, yeah, go the other way. You're not getting through here. So I stayed because I'm like, the person who hit the other person is not at fault. And I saw the whole thing, and I'm going to give a statement because there are going to be lawsuits. I assume at this point, there's at least one, if not more, people that probably wouldn't survive this car accident. So I'm like, again, me working a lot of vehiculars, I'm like, I'm staying and giving a statement to the police. My family is like, so are we going to the Container Store? I'm like, nah, we're gonna be here until we're done making statements. Years later, I am in the doctor's office before my first back surgery and having a conversation about being a DA and working a lot of vehiculars. I'm like, yeah, sometimes I get myself into these situations where sometimes I just do things. I'm like, there was this car accident on Vista Del Mar, blah, 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 blah. And my spinal surgeon stops cold. He's like, wait. He's like, were you the DA that gave a statement to the police? I'm like, yes. He's like, I was the driver. I'm like, wait, what? So then my spine surgeon and I are sitting there having this whole conversation about the fact that years later, he is actually my spine surgeon. And I was just like, what is happening? And so we had a whole conversation about what happened, because I had no idea what happened after the case. Insurance called me. I had talked to the police again, and then I really had no idea what had happened. And so my doctor and I are having a conversation about this afterwards, and it was just absolutely wild. No one passed. Everyone survived, which was absolutely beyond my comprehension based on everything. And so it was just crazy. This doctor was also the surgeon that like helped who was it on a golf course that had a small aircraft crash? I think it wasn't Kevin Costner. Oh, I don't remember. It was an actor who had had a small airplane crash on like a golf course, and he had ended up being the one who like spined that actor as well until he got air flighted off of the golf course. Harrison Ford, that's right. It was Harrison Ford. And I remember seeing it. I was like, why is my doctor everywhere? Why are you golfing in the middle of the day? Spine surgeon. It was crazy. That was Harrison Ford. So it was just, it's a crazy small world in the South Bay. And I'm still dumbfounded that everyone survived that. I mean, when you talk about, you know, these serendipitous moments, the fact that everyone survived that crash is just crazy. Oh, did he land on a golf course? Was it not a crash? Was it landing? I don't remember. I remember that he was there. There was a spine something. That's what I remember. So he wasn't in trouble at all. No trouble at all. He was not at fault in that he was not in fault at all in that collision. And part of the reason is because there were multiple witnesses, not just me, who saw the car that made the U-turn and saw the truck passing. So it was just such a thing. Let's see. Emily's story time should be a thing. That's really truly what we do on the Members Only Lives and in the I Have Thoughts podcast. It's because he's a spine surgeon. He has time to golf in the middle of the day. True. But it is a small world. So the statement helped. I think so. I think all the witness statements helped determine who was at fault. That stretch of road, for anyone who lives in the South Bay, after that accident, that stretch of road has so many signs now that have no U-turn warnings. But it was a mess. And that strip of road had been dangerous for quite a while. So anyway, we're going to go through the last few questions and then we're going to go. How long have we been streaming? 2 hours and 15 minutes. I didn't mean this to turn into a full like ass story time, but it did. Sometimes we do that. Because sometimes we do that, but that tends to be what I do on the Members Only Lives and over on the I Have Thoughts podcast on Patreon. We do a lot more story times there because honestly, we're here to cover the law stuff, but sometimes the brain just. Tomorrow we're gonna spice it up. I'm ready for a spicy soup. My son is 6 and the one word he can read is IKEA. He's obsessed, but we've never been to one. Sarah, it's worth it. Get food. The one in Atlanta is gorgeous. The meatballs are to die for. IKEA is a whole fun day. It is. It's a whole fun day. Real with Robo says soft sits. Believe in the Constitution, unfettered and God-given rights. The official page states Brooks isn't one and won't be due to their beliefs on race, etc. Wait, wait, what? There's admissions into the sovereign citizens? Because I've seen a lot of I've seen a lot of sovereign citizens in court of all races. I didn't know there was official membership. I thought just people came into court and were like, I'm a sovereign citizen. You can't do this. That's weird. And not weird to the commenter, but weird. I didn't know that. Like my knowledge of sovereign citizens is not a whole deep dive knowledge. It's my surface level knowledge from dealing with them in court. Lindsay said, I know you probably won't have an occasion to commentate on Rob in court, but my headcanon is now that he'll be hearing your commentary through every appearance anyway. Maybe Rob. Maybe I'll just narrate Rob's court appearances, right down to whether the court clerks are giving him a little wink because they watch his YouTube channel. Bittersweet. If I'm running, something is chasing me and you should run too. Facts. These are facts. I should put this on the back of a t-shirt. If I'm running, you should run too. Missed all the drama last week because I was getting married. Any married wisdom, Emily? I'll be part of the replay crew this week. Erica, congratulations on your wedding and best wishes. Communication is absolutely key to a good marriage. Just communicate. And remember that you are a team. This is your team now. This is your team. And your team goes before all else. And that is something that has worked well for us. Also, I find separate sinks to be deeply helpful in my household because my husband does not wash all the little facey hairs down the sink, and I hate it. Separate sinks have kept us very, very happy. And do what you need to do to get the best amount of sleep possible. For us, that's not cuddling. I don't want to be touched when I'm sleeping. And we're both on the same page. We want a good night's sleep. If I want to cuddle, I'll sit on the couch and watch a movie and cuddle with you. Once I go to sleep, it's sleep time. Don't mess with sleep time. But that's your partner. That's the person in your foxhole. That's your team. Your team comes first. One of the things my husband and I make sure we don't do, and there's a lot of couples that we've seen do this, and this is what works couple by couple. We do not kind of take pot shots at the other one for a laugh. So if we're with his family, I'm not going to be like, yeah, and you raised your son. He can't do this. Wink, wink. No. Nope. We are a team. We will tease each other, but you can tease my brother, or I can tease my brother, but you can't. It's the same thing. We might tease each other, but we are absolutely not making the other one the butt of the joke ever. That's my teammate. That's my ride or die. That is my person in my corner. And that is my number one person in my corner. That is it. So what is it? Tina asked, is the sleep thing part of being ADHD? I have no idea. I need sleep. I need good sleep. My husband needs good sleep. Both of us take our sleep very seriously. Our sleep is very serious. But it's the team. I mean, that is your team. So, and Emily needs a sink shroom. Tub shrooms have been. I will have to look. But yes, that's your team. And so that's what it is. And we try to be on the same page about stuff. And we have those communications out 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 of the presence of others if we need to have a communication. And that includes our kids. If we need to make a decision, it's like we need to have a conversation about it. And our kids are like, okay, and we'll have a conversation about it. And that's the same with in-laws, that's the same with everything else. We will have a conversation with it, and that'll be between us. So that's it. But we've been together, 24 years? So yeah, it's okay. I know married couples that are very happily married that do sleep in separate beds because they want their separate sleep. My husband's sleep apnea and snoring is treated, so he doesn't keep me awake. So that's very good for me, but it's okay. You might suggest your husband lays a dried hand towel over the sink when he trims to catch hair before the sink and wet washcloth. It's his sink. At this point, if he wants my advice, well, he can go watch it on YouTube. It's his sink. Now it just doesn't matter. Came from the HD podcast. Thank you for covering. You're welcome, Samantha. Let's see. 3 questions. 1, candy corn flavored whiskey. I would try it. I would absolutely try it. Yes or no. Candy corn with the brownie chocolate flavor at the bottom. The Indian corn is not my favorite. I like the OG. 3, can you imagine if Darrell took a positive path as a youth and went to law school? I don't want to ever discount the fact that not all options are available to everyone when it comes to that. Law school is very expensive. It also really does require that you not only go to undergrad, do well in undergrad, and have the ability to do that. So I think that Darrell Brooks is a smart person. I do. He has enough intellect, but it has not served him well in trying to represent himself, because I also think there's an arrogance there that would not allow him to get help when he needed to get help. And you saw how much that strained his mom in her interviews, and how deeply frustrated she was that he didn't have the mental health care that she felt he needed, and that he doesn't think that he needs. Free Flyer said, it's a good morning, drinking coffee, writing my own Rule 48 dismissal, and some juicy Emily Lawnard stream. That's what we're here for. We're going to do just a few more questions, and then we're going to get on out of here and let our mods go, because we are getting to tomorrow's stream, and I gotta go record a podcast. I would truly try candy corn flavor whiskey. I would try it. Question, girl, did you ever ask your stylist what color they use for your hair? I am dying. Valerie, I forgot. I will ask. It's different almost every time, but I will ask. Because I don't know. I made a note and I will ask for sure. My dad says the same thing. He will never call my stepmom his ball and chain like his workmates do. He says, that's my wife and I love her. So why would I say that? Exactly. You should be with somebody who is part of your team. And I will occasionally tell my friends, like, oh my God, sometimes my husband falls asleep on the couch while he watches TV, but I'm not going to complain. We're just not. That's not what we do. Flamingo said, oh my God, it's 4 a.m. already. And I didn't realize. Welcome to the Law Nerd crew. That happens. I'm sorry. Let's give a big thank you to the mods for an extra ride. We will be riding tomorrow. I'm just going to make a plug to follow me on all the things. Make sure your notifications are turned on. YouTube's been going through a whole bunch of stuff. They've changed some of the layouts and stuff. So make sure that you are still subscribed, but B, also you've got your notifications on. I also do notifications over at Law Nerds Unite. Even if you are not a paid member, you will get the notifications, because I will put notifications out there publicly. If you just want to be notified of the stream, you can absolutely do that over at lawnerdsunite.com. You can absolutely say, just follow, even if you're not a paying member of Patreon. It's always an option if you're not getting notified here. I also do notifications on the sometimes the Instagram, almost always on Twitter, and sometimes here. So I try to notify everywhere. This week, I will be at 11 a.m. There will be a new podcast up, the Emily Show podcast, on Wednesday on all your favorite podcasting apps and here at some point during the day, depending on my schedule. And then next week, we'll get next week's election week. And I can't believe it's already election week. If you haven't already gone out and vote, go vote. But next week's election week, and I will be with a friend who's running for judge in LA. So that I will be traveling a little bit. So some of my streaming will be disrupted. So make sure to follow there. And then if you want to be in the text crew, you can just go to textemily.com and I will text you updates when I am going live. So that's all the places. Those are all the things. Thank you all for being here. And we will see you in the next one. Oh, Aurora has a pro tip. Click the notify bell on specific stream when it goes up. Otherwise, YouTube can be rude and not tell you. It's a very good tip. With that, thank you, mods. Thank you, law nerds. Thank you for being amazing. I will see you guys in the next one, which is tomorrow morning at 11 a.m. Central.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just textemily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.